Good evening, and welcome to tonight's Zoning Board of Appeals meeting. Let me introduce some members of town government that assist this board. To my left is Martin Simon, Assistant Town Attorney. To his left is Blaise Donadio, a planner in the Planning Department. You're all here tonight seeking relief from the Smithtown zoning ordinances, and it's our job to try to help you achieve the relief you are requesting whenever possible. It's up to you to provide this board with precise and accurate information so we can make a decision based on the facts presented. This board must consider the 5 area variance considerations in order to render a decision. They're posted up here. Number 1, whether undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the variance. Number 2, whether the benefits sought by the applicant be achieved by some method feasible for the applicant to pursue other than the area variance. Number 3, whether the requested area variance is substantial. Number 4, whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. And number 5, whether the alleged difficulty was self-created. Procedures for tonight's meeting. Cases will be called in the order they are advertised. When you are called, please present your certificates of postings and mailing to Mr. Trotter if you haven't done so already. Then you will be asked to go to the podium, where you'll state your name and address for the record, and then tell us why you need your variance. At the end of your presentation, if anyone in the audience would like to speak on your case, they will be given one opportunity to do so. Then the applicant can go back to the podium to answer their concerns. Once the public hearing is closed, no further information will be accepted concerning the case. There are 2 ways to find out about your case. You can call the planning office tomorrow after 12 p.m., or you can wait and be notified by mail.
Mr. Chairman, the first case on the agenda, case number 18926, Edward Owinski, 19 Tyrum Street, Comac. The location of the property is the north side of Tyrum Street, 672 feet west of Montrose Drive. The property is zoned R10. The applicant is requesting variances to reduce the minimum front yard setback from 40 to 35 feet for a proposed 35-square-foot portico, to increase the maximum permitted paved surface in the front yard from 25% to 32% for an existing asphalt driveway, to increase the maximum permitted paved surface in the west side yard from 25 to 60% for an existing asphalt paving, to increase the maximum permitted paved surface in the east side yard from 25% to 47% for existing concrete paving, to reduce the minimum setback of paving from the front and side property lines from 1 feet to 0 for existing paving.
Is the applicant here? No? Case 18926, the applicant? All right, we'll move on.
Move on, okay. The next case on the agenda is case number 18927, Glenn Tannenbaum, 94 Stephen Place West, Hauppauge. The location of the property is the north side of Stephen Place West at the terminus of Stephen Place. The property is zoned R15. The applicant is requesting variances to permit environmentally sensitive lands to be altered where depth to groundwater is equal to or less than 10 feet, to permit structures within 100 feet from any wetlands for a proposed 20-foot by 44-foot in-ground swimming pool.
Good evening.
Good evening. Hello, Mr. Chairman and members of the board. My name is Glenn Tannenbaum. My address is 94 Stephen Place West in Hauppauge. My family and I have been residents in Smithtown since 1993, almost 30 years. I'm here tonight asking for a variance for an in-ground swimming pool. My wife has back issues and has had 3 back surgeries already. Her doctor has recommended exercising and swimming in the pool to alleviate the pain. In regards to the 5 variance considerations, the pool would not have an impact on the adjacent properties Our two neighbors behind us both have 6-foot fences separating our properties, and my one neighbor on the side has 6-foot hedges separating the lines, so there would be no visibility. It's not a substantial variance we're requesting, as the pool will only be in one corner of our property. And these benefits cannot be achieved via alternate methods. It would not cause adverse effects to the environment, as the area is properly fenced in and it's not visible to the street or the neighbors. We've discussed it with our neighbors. Both our neighbors behind us have in-ground pools already, and our neighbor on the side of us, he doesn't have a pool, but we've discussed it with him, and he has no issues with us having the pool. And this was not created by us, as we were seeking the variance ahead of time before starting this project. I'd like to thank you and have a good evening.
Great, thank you. Does anyone on the board have any questions on this application?
No, thank you.
Planning?
No, thank you.
Sabrina?
Mr. Chairman, the property is located within 100 feet of New York State DEC mapped freshwater wetlands and appears to require a permit from DEC. This department has notified the applicant of their need to contact DEC to determine permitting requirements. We need this information in order to complete our review. The proposal to construct a 7-foot deep pool with a depth to groundwater of only 5 feet raises concerns regarding dewatering activities during construction and potential groundwater contamination. DEW wishes to consider information presented by the applicant, as well as any comments received from the public before making a recommendation. Therefore, no decision will be made tonight.
Okay. Did you get the letter, sir?
Yes, we did get the letter, and we are starting the process with New York State on that.
Okay. Thank you.
Thank you.
Is there anyone in the audience like to be heard on this application? No? Can I have a motion to close the application, please?
So moved.
Motion has been made to close the application. It's been seconded. All in favor? Aye. Motion carried. Thank you.
The next case on the agenda, case number 18928, Agnes Bianculli, 110 Florida Avenue, Comac. The location of the property, the south side of Florida Avenue, 1,128 feet east of Shinbone Lane. The property is owned R10. The applicant is requesting variances to reduce the minimum distance from any lot line from 6 feet to 1 foot for an existing 286-square-foot shed, to reduce the minimum front yard setback from 40 feet to 4 feet for an existing 6-foot PVC fence.
Good evening.
Good evening, how are you? I'm Teresa Catalano. I'm here, I'm a little nervous. I'm here on behalf of my mom, who's 84 years old, Agnes Bianculli. The fence in the front yard is almost like a privacy fence. We live next door to a factory, and they're building the factory. I do have video if anybody wants to see it. The factory was only supposed to go up 5 feet. They took the whole factory down, and they drive right in the court. Besides, the court is a safety factor. People are in and out of the court doing constant things. So it's kind of like a privacy. It's been there for a very long time. The barn's been there for a really long time. She's 84 and can't walk. So I don't even know. I'm praying to God that you could just have compassion on her. That's it.
And that's a court.
Yes,
So the only
There's a
way,
buffer.
the only way you could enter that is through that road right there that you see.
yeah,
Is-
that's my mom's
Right,
house.
Right,
Yes.
so you just go in, you have to turn around and come
Yes,
back out.
yes.
Okay. Anyone on the board have any questions on this application?
Thank you.
Planning?
No, thank you.
Sabrina?
Mr. Chairman, the survey submitted by the applicant indicates the following encroachments. As we have learned, a portion of the existing PVC fence encroaches onto the town right-of-way to the north and onto the industrial parcel to the east. A portion of the existing stone wall and concrete block wall encroach onto the town right-of-way to the north. A portion of the existing driveway and wall encroach onto the residential parcel to the west, and a portion of the roof over attached to the existing shed encroach onto the residential parcel to the south. DEW recommends that any approval include a condition which requires the removal or legalization of these encroachments. Additionally, the survey indicates that an existing 242-square-foot detached garage is located in the front and side yards and would appear to require a variance. Planning has notified DEW that the applicant proposes to remove this garage.
It is removed. Thank you.
Did you
Thank you.
understand about the encroachments?
I don't understand it, but that's okay. It's fine. You have
The
to.
survey shows that there's encroachments, there's like a retaining wall right on the property line that
It's,
encroaches.
it's little brick. Do you
Okay.
want to see it? I have it on video. And you could see the whole factory and what my mom lives next to. You know, I don't
That's
know if
up
that
to the-
helps.
No, I don't think,
Yeah.
Are you sure?
yeah. The encroachments have to be taken care of.
Okay,
So if it's on town property, it has to
So-
be moved.
so the brick would have to be moved.
Yes,
That's stone. It's stone and flowers,
right.
like an end cap.
There's the fence, there's the brick wall, there's part of the driveway. That's what the survey, is going by the material that's been submitted, so.
And part of the driveway?
There's a portion of the existing driveway, and there's a retaining wall along the side, too, that encroaches onto the neighbor's property. So we're just recommending a condition which either requires the removal or legalization. Whether you work that out with the neighbor, I don't know what the legalities are
Because
there.
it's a buffer zone. There's nobody next to us.
That's for the fence, but then there's
Yeah.
additional encroachments. I don't know if there's any other photos. No? Okay, all right.
I'm sorry. Right,
So, yeah, we're just recommending that these encroachments have to be removed. So there's the fence that what we see
Yes.
there, okay? Then there's a portion of the existing stone wall and concrete block wall that are along the property line in front of the house. So those, yeah, those boulders. And then there's a, I don't know if this, do you have a survey? Is a survey submitted there? Yeah. Is there a way you can zoom in? It's probably easier to see a visual. So if you could take your mouse, so there's, where it says stone wall there, that portion encroaches, you can see that up there. And then there's a portion right there, that's part of this retaining wall, it's in the town right of way. And then behind the shed, there's a portion of the garage that slightly encroaches, so,
the shed is no longer there, that shed.
correct. But there's a small portion of the driveway that does encroach onto the neighbor's
That would
property.
have to be cut back.
Correct.
And then in the front, you're talking, because there's no, my neighbor and I, they're original, and there are no sidewalks there, so that's been there since I'm born.
Okay.
Do you know what I mean? So there's no sidewalk going, so they have the same thing, you know what I mean, as we do.
Okay.
Okay, thank you.
Right. Is there anyone in the audience to be heard on this application? Can I have a motion to close the application, please?
So moved.
Motion has been made to close the application, it's been seconded, all in favor? Aye. Motion carried.
What?
You want to go back to the first one? See if he's,
Has anybody come in? You wanna add-
Mr. Oswinski? No? Okay.
No? Okay. All righty. The next case on the agenda, case number 18929, Alexandra Fagione and Travis Zaleski, 2 Haven Lane, Smithtown. The location of the property is the west side of Haven Lane, 211 feet north of Tanglewood Drive. The property is zoned R10. The applicant is requesting a variance to reduce the minimum rear yard setback from 50 feet to 43 feet for an existing 97-square-foot rear deck.
Good evening.
Hi, my name is Paul Fagione. I'm representing Alexandra Fagione and Travis Zaleski. This is an ongoing variance. It was started by the former owner. when my daughter bought the house, it was stipulated that she was going to get everything taken care of, the COs, the variances, so forth. Since then, she went like halfway through, and she dropped the ball, and now it's in my daughter's lap. Everything was under her name, and now everything is under my daughter's name. She was apparently asked for pictures and, measurements and everything, and she didn't provide it. So we're here today with all that stuff, and I hope that's sufficient.
Okay, thank you. Does anyone on the board have any questions on this application?
Oh, thank you.
Planning?
No, thank you.
Is there anyone in the audience like to be heard on this application? Can I have a motion to close the application, please?
So moved.
Second.
Motion to close the application, it's been seconded.
Thank you.
Do you want to see if they're here?
All right. Edward Osinski, is he here? Nope.
Okay.
Okay.
All right, the next case on the agenda, case number 18930, Panayotis Korovivos, 71 Boban Drive, Nesconset. The location of the property is the east side of Boban Drive, 421 feet north of Roy Drive. The property is zoned R10. The applicant is requesting variances to permit environmentally sensitive lands to be altered where depth of groundwater is equal to or less than 10 feet, to increase the maximum permitted paved surface in the rear yard from 25% to 42% for a proposed patio.
Good evening.
Hi, good evening. Good evening. Thank you for seeing us tonight. My builder is actually right outside. He stepped out to the car to grab something, and I believe my husband is giving the affidavits that we need to turn over.
Okay,
I don't know where he went right this second. He was just here.
you're waiting for your builder.
Yes, he was here sitting next to me, and he ran out to his car. I don't know if you like to see somebody else, so we don't waste anybody's
He's
time.
going to come back, right?
Yes, yes. I
Okay.
hope he didn't run off, unless he got scared, but he should be back.
We'll give him a minute.
Okay, thank you so much.
Is this him?
Nope, that is not him.
No?
Here he is.
Here he is.
Okay.
Oh, excellent.
Okay, one second. Okay. Would you like this gentleman to speak on your behalf?
Yes, please.
Okay. Sir, if you could introduce yourself, state your name, correct on the record, and your address, please.
My name is Joseph Damiano. I reside at 6 Riviera Court, Wading River, New York, 11792. Last name is spelled Domiano.
Okay, thank you.
You're welcome. I'm the swimming pool contractor. We built the swimming pool last year and filed for a variance. Everything went through great. Got a test hole prior to the job being done. Everything passed, flying colors. Now we're looking to put a patio, and they're sending us out a letter stating that the test hole has to be done for the patio. Which is, I called up to ask what the precedence was for that and what the meaning was. They couldn't answer my questions. They said to bring it up tonight because they were unclear as to what had to be done. So we're looking to get passed for the variance so we can complete this man's patio and retaining wall and put his backyard back together.
Okay. Anyone on the board have any questions on this application?
Nope.
Planning?
Thank you.
Chairman, in the presence of high groundwater on the property, the applicant has been notified that the submission of new test hole data within the past 6 months is required. We need this material in order to complete our review. Therefore, no decision will be made tonight on this application.
So another hole has to be dug.
Yes.
For a patio.
It has to be within the past 6 months, and that previous test hole data is from a year ago, so.
We didn't hit water when we built the pool. I just, I don't mean any disrespect, I just don't understand why we would have to go through that and prolong this whole process for a patio that's going down into the earth 2 inches.
No, I understand, but this is what we need at this time, so.
If I may, even if, excuse me, I'm just, my name is Panayotis Korovezos, I'm the owner of the property. The retaining wall was built at the same time as we did the pool, so the original test hole for that project should suffice for the wall, I'm imagining, because it was done at the same time. I guess I'm just kind of questioning why a patio, if you don't mind, and with, all due respect.
I wish I could give you a better answer, that we just, our policies, it has to be within the past 6 months, and it's beyond that, so.
If, given the winter that we just had without a whole lot of precipitation, I'm assuming that if we did the test hole and, started the project that we, completed last year and we started it this year, I'm imagining that ground, like the 10-foot mark, we probably would not even hit this year, which most likely wouldn't have even drove us down the road to have to get a variance for the original pool project. If we do the test hole again at this point, I'm only going to take a wild guess. I'm certainly no expert, and environmental and water drain, everything that comes with the groundwater level. But I'm assuming we're probably not even going to hit groundwater at the exact depth that we hit it the first time. I mean, is that something that you would consider at all? Because
You're more than welcome to call the department tomorrow, and we can discuss this further, but no decision will be made tonight. But there's likely we could resolve this between now and the next meeting.
okay, because when I called that office, they told us that we should just come here and. Okay. All right. Thank you very much for your time.
Okay. One sec. Is there anyone in the audience like to be heard on this application? No? Can I have a motion to close the application, please?
So moved.
Second.
Motion has been made to close the application. It's been seconded. All in favor? Aye. Motion carried. Sorry? Oh, you're Edward. Okay. All right, we'll go back to the first case. Certificates of postings and mailing, did you hand them in over? Mr. Trotter will take them.
I don't know that he's.
You want to read it again?
Yeah, I'll read it again. Going back to the first case on the agenda, case number 18926, Edward Ozinski, 19 Tyrum Street, Comac. The location of the property is the north side of Tyrum Street, 672 feet west of Montrose Drive. The property is zoned, R10. The applicant is requesting variances to reduce the minimum front yard setback from 40 feet to 35 feet for a proposed 35-square-foot portico, to increase the maximum permitted paved surface in the front yard from 25% to 32% for an existing asphalt driveway, to increase the maximum permitted paved surface in the west side yard from 25% to 60% for existing asphalt paving, to increase the maximum permitted paved surface in the east side yard from 25% to 47% for existing concrete paving, to reduce the minimum setback of paving from the front and side property lines from 1 foot to 0 for existing paving.
Good evening.
Good evening.
You
My
state your-
apologies.
Could you state your name and address for the record, please?
Salvatore Koshia, Permits are us, 338 Jericho Turnpike, Syosset, New York, 11791. I'm here on behalf of, COSCIA. I have a disclosure that he gave me authorization to represent him at the hearing. It was submitted at the Zoning Board of Appeals.
I don't have a copy of it.
No.
I don't have a copy of it.
You fill out a power of attorney?
If you'd like me to, I'm more than happy to do it.
What's that?
But it was submitted, the board knew that I was representing for my client, he's not here.
He also has an issue with the date for this.
Yeah, we need a power of attorney.
What's that?
We need a power of attorney regardless of what's on the application.
Yeah. We need the power of attorney.
Okay, so whatever was submitted to the Zoning Board of Appeals, you don't have it here in front of you. He had given an authorization for me to represent him at the hearing.
Unless you
He's
go,
talking about the little line that's on the application that says your person is authorized to represent them.
That as well, yes.
It's
They didn't
all-
ask for a specific
It's
power
not-
of attorney as
Yeah,
well.
no, that's just on the form, that's not a power of attorney. You would
Okay.
need a separate one for that.
No, he didn't fill out a power of attorney. He had written a letter, but okay. What do we need to do then?
if you could get your, get the applicant to come down,
Unfortunately, he's not able to make it tonight, which is why I'm here,
okay. And then I'll have to postpone it to the next meeting.
which is when?
June 13th.
June 13th. Okay. So be it.
Yes?
The power of attorney needs to be submitted 10 days prior to the date of the hearing. So when they get the power of attorney, they need to submit it to planning 10 days prior to June 13th. So by June 3rd, we need to have the power of attorney in our office.
Okay,
Okay?
not a problem.
Well, we'll make it June 2nd then. How about that?
All right, so we're going to adjourn this to June 13th.
Very good.
All right?
One quick question. In the event that because I know he's with his children tonight, but in the event that he's able to show up this evening at some point in time, if he's able to show up this evening for some reason, because he's with his children, he doesn't have everybody to watch them, but if he's able to come, we'll be able to reopen this tonight?
If he shows up, then we're still here.
Okay, all right. I'll give him a call, see if he can. If not, we'll
Okay.
keep the adjournment date.
Okay.
Thank you.
Very much.
No problem.
Okay.
Or not.
Or not. I'll put a question mark on that. Okay. The next case on the agenda is case number 18931, Michael Hogan, 124 Scarlet Drive, Comac. The location of the property is the east side of Scarlet Drive, 744 feet northwest of Rhett Court. The property is zoned R6. The applicant is requesting a variance to increase the maximum setback of paving from the rear of the dwelling from 10 feet to 15 feet for a proposed 15-foot by 20-foot paver patio.
Good evening.
Good evening. My name is Michael Hogan, 124 Scarlet Drive, Comac, 11725. And my purpose is to seek the variance for an extension. We're allowed to build a patio 10 feet from the structure currently. We're seeking a variance to build a patio, a paver patio, to 15 feet from the structure.
Tara, right? That,
Yes, that's correct.
anyone on the board have any questions on this application?
No, thank you.
Planning?
No, thank you.
No, thank you.
Is there anybody in the audience like to be heard on this application? Can I have a motion to close the application, please?
Second?
To close the application, it's been seconded. All in favor?
Aye.
Motion carried. Thank you.
Thank you.
The next case on the agenda, case number 18932, Matthew and Fatima Lavelle, 81 Smith Street, Nesconset. The location of the property is the northeast corner of Smith Street and Eklund Boulevard. The property is zoned R10. The applicant is requesting a variance to reduce the setback from lot line on Eklund Boulevard from 10 feet to 5 feet for a proposed 6-foot PVC fence.
Good evening.
Good evening, Chairman and members of the board. I apologize for my son's disruptiveness. Fortunately, the babysitter kind of jumped ship on us. My name is Matthew Lavelle. This is my wife, Fatima Lavelle. We live at 81 Smith Street, Wisconsin, New York, 11767. We've been residents of the house for the last 7 years. We are seeking a variance to install a fence along the property line, 5 feet within the property line, 6-foot PVC fence for my son and our future child on the way to protect him. Unfortunately, the 4-foot fence would not meet the standard because our little guy is a little bit of a terror, and he would be able to get over the 4-foot fence. So we're looking for the approval for the variances to get something to protect him for the future.
Mr. Donato,
Okay,
no obstruction to oncoming traffic.
okay. Perfect.
Okay. Anyone on the board have any questions?
No, thank you.
Planning?
No, thank you.
No, thank you.
Anyone in the audience like to be heard on this application? Can I have a motion to close the application, please?
Second.
Motion has been made to close the application. It's been seconded. All in favor?
Aye.
Motion carried.
Thank you very much.
The next case on the agenda, case number 18933, Hatis Aslantis, 71 Ledgewood Drive, Smithtown. The location of the property, the northeast corner of Ledgewood Drive and Argyle Place. The property is owned R21. The applicant is requesting a variance to reduce the minimum side yard setback from 16 feet to 14 feet, which is existing for a begun prior, 408 square foot first floor addition, 2,287 square foot second floor addition, and a 259 square foot front covered porch.
Hi, good evening. My name is Hatisa Lantes. I own 71 Ledgewood Drive, Smithtown, New York, and I would love to have Mr. Grasso represent me on this application, please.
Fine. Thank you.
Thank you.
Good evening, Mr. Chairman. My name is Carmine Grasso from Cataldo Grasso Architects, office at 14 Carl Avenue in Smithtown. I represent Ms. Hatisa Aslantis in her request for a side yard setback variance. The house received the setback variance when it was constructed back in 1964. The side yard is like 14.1 feet. What we're seeking to do is maintain the existing side yard setback and expand the house, expand the second floor on the house. It's a single level house right now. And also put a sunroom in the rear of the house along that same property line, so that would be on that same 14-foot setback. We meet all of the other setbacks and the FAR, so there would be no other variances required on that end. I do know that we had a question from DEW that came up regarding the number of bedrooms in the house. I've actually spoken with DEW. I've spoken with David Barnes and also with the health department to verify if there's any issues with the number of bedrooms. The plans that we have show 8 bedrooms. It actually is only going to be 7 bedrooms. There's 1 bedroom on the first floor that actually is going to be a living room or a den. It's in the back left corner of the first floor. So even with regard to that, the health department has said that they don't have any kind of limit as far as the number of bedrooms on the property, as long as you can fit a code-compliant sanitary system. In my emails back and forth with David Barnes from DEW, he said that they would be fine with issuing a secret declaration on this project once they have a receipt of submission to the health department, which we are in the process of doing right now. With respect to the area variance considerations, we don't feel that there's an undesirable change to the character of the neighborhood because we're maintaining the existing setback, so it's not going to encroach any further to the neighbors' properties. Whether the benefit could be sought by another method, no, unfortunately, it's an existing setback, and we're just, anything we do on the building would require a variance. Whether the requested variance is substantial, we don't feel it is. It's a 2-foot encroachment on the required setback. Whether the proposed variance would have an adverse impact on the neighborhood or the physical environment, we don't feel it would. The setbacks, again, is existing, and it's staying the same single-family use. And whether the alleged difficulty was self-created, no, it's been that way since 1964 when the house was built. If you have any questions, myself or my client would be happy to answer.
What's going on in the basement? You have a
Excuse me?
full basement?
Yes, there's a full basement in there. They're finishing the basement as part of the house.
Right, what's going to happen down there?
It's just an open, it's an open, pretty much, I think there's some rooms where there's like a mechanical room and then a laundry room and a bathroom, but other than that, that's,
So you have a full bathroom down there?
yes. There's actually, the bathroom down there actually exists.
Okay.
It was there when they purchased the house.
All right, so you have 8 bedrooms, a full
So
basement?
Well, it's going to be 7 bedrooms, not 8.
Okay,
That
but
that plan, that we do have to change something on that plan, because that one room in the back corner, if I could just grab it. Actually, right where you have circled up there, where the sunroom is,
Right.
right in front of that is, right, that's going to be a living room. So there's only 2 bedrooms in the front and then the 5 upstairs.
and then you have a sitting area upstairs, right?
Yes, let me look at the.
Anyone on the board have any questions on this application?
No, thanks.
Planning?
No, thank you.
Mr. Chairman, as Mr. Grasso stated, we recommend that the board withhold action on the application pending receipt of a decision from the Department of Health before making a recommendation, and we wish to consider information presented by the applicant as well as any comments received from the public before making a recommendation. So therefore, no decision will be made tonight. Thank you.
All right, Carl.
Thank you very much.
Okay. Is there anyone in the audience like to be heard on this application? Can I have a motion to close the application, please?
So moved.
Second.
Motion has been made to close the application. It's been seconded. All in favor?
Aye.
Motion carried. Thank you.
Thank you. Have a good night.
You too.
The next case on the agenda is case number 18934, Phoenix Salons of Comac LLC, Kevin Davis, 108 Veterans Highway, Comac. The location of the property is the south side of Veterans Memorial Highway, 900 feet west of Sunken Meadow Parkway. The property is zoned SCB. The applicant is requesting a variance to increase the maximum height of a wall sign from 15 feet to 25 feet for a proposed 103-square-foot illuminated wall sign.
Good evening.
Good evening, Board. How are you? My name is Marcela Granada. The spelling is Granada, and I am a representative of the applicant, and I did submit a power of attorney.
You submitted it, right?
Yes.
Okay.
Oh, yeah, sorry. So my client would like to, just put up the sign on this area. As you can see, if you even look at the other, yeah, thank you. At the other shops, they have similar, it's all very similar size. We're not asking for anything different than what it is there. It's just basically that we're able to add that sign up so that they can start, so the business looks the right way. And again, this also is Phoenix Salons, as you can see, is a growing salon suites that they use the same sign, so it's not like they're using something special here. They're using that throughout every one of their departments that they're using.
How long does the sign stay illuminated at night?
That's a good question. I'm not really sure, but that's something I can ask the company that's making the sign, because that could be something that could be controlled.
Right.
Yeah, they could. I know that this, from my understanding, is that you can put a timer on the sign. So if that's something that you guys would like to discuss further, we can definitely discuss it.
Okay. All right, thank you.
Thank you.
Anyone on the board have any questions on this application?
No, thank you.
Planning?
No, thank you.
Nothing. Anyone in the audience like to be heard on this application? Can I have a motion to close the application, please?
Second.
Motion has been made to close the application. It's been seconded. All in favor?
Aye.
Motion carried. Thank you.
Thank you. Good evening.
The next case on the agenda, case number 18935, David and Dana Bohm, 30 Delmarie Lane, Nesconset. The location of the property is the west side of Delmarie Lane, 86 feet south of Yardley Lane. The property is zoned R10. The applicant is requesting variances to reduce the minimum side yard setback from 12 feet to 0, to reduce the total side yards from 28 feet to 15 feet, for an existing 74 square foot shed, to reduce the minimum distance from any lot line from 6 feet to 0 for existing pool equipment.
Good evening.
Good evening, Mr. Chairman, board members. My name is James Zapka from Todd O'Connell Architects. We're at 1200 Veterans Highway, Hauppauge, New York, 11788.
Excuse me.
Do you need the spelling?
Do you have your affidavits of posting and mailing and your receipts?
And you submitted the power of attorney?
Correct.
Thank you.
Sure. ZAPKA. As you stated, Mr. Chairman, we're here tonight to maintain two items on this property, one being the existing pool equipment and the other being a plastic shed in the side yard. I just want to let it be known that the pool was actually installed in 2008, and the equipment and everything had passed the inspection. So that has not moved or changed since that date. They had previous plans to actually remove that pool. We were in front of this board probably 2 years ago for the maintain of the rear shed. But the plans had changed, and they decided to keep that, redo the backyard around that existing pool that remains there now. The pool equipment that is there has a very large evergreen buffer between them and their bordering neighbor. They've already spoken to the neighbor, and he has no objection to the equipment staying where it is. For the plastic shed, they would like to have that remain in place as it is on a base. And since they've redone the backyard, they're looking to have more storage for their chairs and everything. So instead of ripping that one out, moving it, putting it on a compliant place, they would like to keep that one intact. It's not obtrusive. It only stands about 18 inches above the 6-foot PVC fence from the street line. And like I said, they already spoke to their neighbor, and they don't have any objection to that remaining there as well.
Okay, thank you. Does anyone on the board have any questions on this application?
No, thank you.
No? Planning?
No, thank you.
Is there anyone in the audience like to be heard on this application? Have a motion to close the application, please?
Second.
Motion has been made to close the application. It's been seconded. All in favor?
Aye.
Motion carried. Thank you.
Thank you. Have a good night.
You too.
The next case on the agenda, case number 18936, Dana Morfaglio, 6 Crusader Lane, Nesconset. The location of the property is the southeast corner of Crusader Lane and Heritage Place, south. The property is owned R15. The applicant is requesting variances to reduce the minimum front yard setback from 45 feet to 10 feet on Heritage Place South for a proposed 18-foot by 40-foot in-ground pool, to reduce the setback from lot line on Heritage Place South from 10 feet to 0 for a proposed 6-foot PVC fence.
Good evening.
Hi, I'm Dana Marfoglio at 6 Crusader Lane, Nesconset, New York, 11767, the owner, along with my husband, of the property, and we are allowing Dieter Speck to discuss.
This gentleman's going to speak on your behalf.
Yes, exactly.
Okay.
Thank you.
All right.
Hi, Board. Hello, my name is Dieter Specht, Spectacular Pools. Office is at 265 Brookfield Avenue, St. Marches.
Can you spell your last name so we get it correct on the record, please?
Specht.
Okay, thank you.
So we're looking to put a pool in on the corner lot here. The property ends right behind the house on Heritage Place. There is only one neighbor across from them, which I have a letter of recommendation, which we submitted. And then there is only a sump on the property. So there's only one neighbor affected, and that ends at the Heritage Place South ends on the south side. So there's no really through traffic at all there. All right, and then I guess there's only one neighbor, and we have a letter of recommendation.
Yeah, Mr. Donadio and I rode by the house yesterday.
Okay.
And the fence, it's not going to obstruct anybody's view.
Not at all.
Won't hinder any traffic whatsoever. Okay. Anyone on the board have any questions on this application?
No, thank you.
Planning?
No, thank you.
Anyone in the audience like to be heard on this application? Can I have a motion to close? Excuse me, can I have a motion to close the application, please?
So moved.
Second.
Motion has been made to close the application. It's been seconded. All in favor?
Aye.
Motion carried. Thank you.
Thank you for your time.
The next case on the agenda, case number 18937, One Spectacular Home. 269 North Country Road, Smithtown. The location of the property is the north side of North Country Road, 203 feet west of Panzer Street. The property is zoned R10. The applicant is requesting variances to reduce the minimum road frontage from 40 feet to 25 feet, to reduce the minimum lot frontage at the setback line from 75 feet to 25 feet, to permit environmentally sensitive lands to be altered for slopes greater than 15%, to permit construction within 10 feet of any slope greater than 25% for a proposed 2,325 square foot, two-story single-family dwelling with a 470 square foot attached garage.
Good evening.
Good evening, Mr. Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. We've submitted the affidavits of posting and mailing to Mr. Donadio. This property has a very long history. Some of the board members may remember a developer many years ago, Sisto Rotundi, and he developed this whole area where we are asking for a variance. And when he developed it, most of the time, they dedicated the streets to the town. In this case, they only dedicated half the street to the town. So the members on one side, the homeowners on one side of the street had the property to the center line of the road. The road was never built because they have access, all parties have access on the opposite streets on each side. The reason why I bring it up is we are now applying for a variance for Spectacular Homes, and you can see on the survey that we need a few variances we actually bought the 25 feet that you see, the leg of the flag or the pole of the flag. So my client owns that 25 feet, and because he owns it and it's part of the lot, we need two variances. One, road frontage variance from 40 feet to 25 feet, and setback variance because the house or the plot is set back more than the front yard setback. So those two variances, I think, are pretty easy to see on the survey. The third variance is steep slope variance. It's a very moderate incursion into the steep slopes in order to build the house. We had a couple of different options. One, we could have pulled the house closer to the road, but the town of Smithtown has a drainage pipe, but they don't know where it is. It's somewhere within that roadway that I'm talking about. So the highway department felt the better part of valor is discretion, and so we kept the house back, and that forces us to go a few feet into the steep slopes. And that basically is the last house to be built in this unique kind of situation. The side where the house is, we actually had to ask the town to accept dedication and get deeds from basically the survivors of Mr. Rotundi. So here we are tonight. It's kind of the end of our journey, and we're asking the board for its favorable consideration. It won't produce any change in the character of the neighborhood. The neighborhood is basically there except for this one new house. Whether the benefit can be sought by any other means, this was the best alternative. We don't have an easement to get to our property. We actually own that 25 feet. Whether the requested area variance is substantial, not when you look at the survey and why we did what we did. That's really the only way to get to the property. And whether we'll have an adverse effect on the environment, actually will not. It meets all the requirements of the town, except for the variances that we're asking for, and more than meets the health department requirements, which, by the way, we did get health department approval twice. It expired twice because it took a very long time to figure this whole thing out and deal with the town and the neighbors, who were all very cooperative, and we thank them. So we asked the board for its favorable consideration. The difficulty wasn't self-created. It was probably created about 70, 80 years ago when this mishap happened. I'm sure it wasn't intentional. It was just maybe a Scribner's error, because I don't know how you dedicate half a street and not the other half, but anyway, that's what happened. So we asked the board for its favorable consideration. Thank you.
Thank you. Does anyone on the board have any questions on this application?
Just for clarification, the street dedication, the 25 feet that's owned by your client, the other 25 feet of the road is?
To the other,
To the other.
the homeowners.
Okay, thank you.
Planning?
No, thank you.
Mr. Chairman, the current application to create a 5-bedroom dwelling requires Suffolk County Department of Health approval. As Mr. Chamarko has stated, the applicant did receive Health Department approval in 2014 for a 6-bedroom residence, which was renewed in 2018 and then expired in 2020. DEW recommends that the board withhold action pending a current receipt of an application to the Department of Health to renew this application or a new application for this project. We have notified Mr. Tramarko of their need to provide a copy of submission to the Health Department so that we can complete our review. We wish to consider any information presented by the applicant, as well as any comments received from the public before making a recommendation. Therefore, no decision will be made tonight. Thank you.
I'd like to comment, Mr. Chairman.
Go right ahead.
I've been doing this for a very long time. My friend Don King did it for a very long time, and we had a basic complaint, and I don't think it's ever been fixed, so to speak. The building department will never, ever issue a permit for this project until we get health department approval. So I don't know why the Department of Environmental and Waterways is saying, oh, let's wait to see if we get approval from the health department. The board could very easily make their variance subject to the health department approval if you don't have enough, I shouldn't use the word faith, but the building department will never, never issue a permit. So I don't know where the environmental department is, you know, getting involved in this, and all it does is build up the calendar and, you know, on adjourned cases, which is very unnecessary.
But we don't have a CEQA. They have to give us the CEQA, so we can't make the decision until we get the CEQA.
Yeah, I guess my,
I mean, yeah.
I
unless-
understand. I guess my statement is,
Yeah.
they should have a secret, and they don't, so, anyway.
Well, we can't provide a recommendation until we know this can be built. So we want to verify that it can be built before we can provide the board a recommendation.
Okay, so the DEW is controlling here. Thank you.
Thank you. Is there anyone in the audience like to be heard on this application? Can I have a motion to close the application, please?
So moved.
Second?
Motion has been made to close the application. It's been seconded. All in favor?
Aye.
Aye. Motion carried. Thank you.
Thank you. Mr. Chairman, you're going to hear my request to reopen after you're done with the hearings? Whenever the boss, whenever you say.
It probably won't be tonight.
Well, I
Yeah,
just
we
want to indicate the problem. If the board decides in its discretion not to hear it, 30 days will have elapsed by the time the next hearing is, and I'll have no choice but to preserve my client's rights is to bring an action, which I absolutely don't want to do. That's why I put it in the way I did. I'm not, you know, trying to be pushy, but I have a 30-day window, and it's probably almost half done already, so. Okay.
Just got the letter. You have to read it and have to talk
All right.
about it.
Okay, thank you.
You can call the office tomorrow.
I'm sorry?
I said you can call the office tomorrow.
Okay, all right, thank you.
Okay. What? We'll do one more, and then we'll take a break. Huh?
She said she's okay now.
Yeah. Blaze will do one more, and then we'll take a break.
Yes. The next case on the agenda is case number 18913, Frank Wally, 10 Nadia Court, Smithtown. The location of the property is the east side of Nadia Court, 425 feet east of Landing Avenue. The property is zoned R43. The applicant is requesting a variance to reduce the total side yards from 60 feet to 48 feet for an existing 217-square-foot gazebo.
Good evening.
Good evening, Mr. Chairman, members of the board. Kevin Guilfoyle of Island-Wide Permits, 86 Center Street, Ronkonkoma, for the applicant. The applicant is with me this evening, Frank Wally.
I need the applicant first, sir.
Okay.
Yes, Mr. Chairman.
Yeah.
My name's Frank Wally, W-H-A-L-L-E-Y. I reside at 10 Nadia Court, Smithtown, New York, 11787, and I give this gentleman the right to speak for me.
Fine, thank you very much.
You're welcome.
Okay,
Sorry about that, Mr. Chairman.
it's okay.
Mr. Chairman, members, members of the board,
Spell your last name.
yes, I'm sorry, Guil, F as in Frank, Oyle. Mr. Chairman, members of the board, my partner handed out a pamphlet with some photos and a copy of the survey showing the gazebo highlighted, and on the bottom of that page is an aerial showing the location of the existing gazebo to the side neighbor who would be most impacted by that. And if you notice in the photo, there's a heavy degree of shrubbery. On the second page is a shot of the driveway looking in with the gates open where you can barely see the shed. It's visually almost invisible from the street. The neighbor really has no knowledge of its existence. We also enclosed a photo of the existing gazebo. The gazebo itself is holding roughly 24 feet, 26 feet side yard, but because of the existing concrete patio in that same vicinity, it reduces the total side yard to 48. Now, that's a 20% relaxation. It could be considered maybe substantial, but in this particular instance, where we're talking about a total side yard due to a concrete patio that's also not visible to anybody, the neighbors. From this standpoint, we don't consider the relaxation that we're asking significant. We don't think it's going to materially change the nature and character of the neighborhood. And yes, it might have been self-created, but based on the way this property is situated and what was constructed in the rear yard, just about any gazebo in that area probably would have facilitated some type of variance. And we're here to answer any questions you may have.
Thank you. Anyone on the board have any questions on this application?
No, thank you.
Planning?
Just one comment, Mr. Chairman. Part of the subdivision of Nadia Court, there was a 100-foot buffer created between the Landing Meadow, Landing Avenue Country Club to the south, and the houses on the cul-de-sac within Nadia Court. The applicant currently has a bocce court located within that 100-foot designated area. So the board may wish to consider, if they consider approving the application with the condition that the court should be removed.
The bocce court has been removed.
Okay, because the survey that we have submitted with the application indicates that it's still there.
Okay, it shows a gravel area? Yeah, just a gravel area on a
Well,
survey?
it's labeled bocce court, so I'm assuming.
May I submit this to the chairman? This is an updated survey.
I'll put this in the record.
Planning also made note of an existing wire fence that is theoretically, not theoretically, but is actually the neighbor's fence. It's not our fence, and it lies within that 100-foot easement area. I had received correspondence from Mr. Barnes' office regarding that matter. But the bocce court has been removed, the gravel will be removed, and natural vegetation will be replaced.
Okay. Sabrina?
Mr. Chairman, DEW has notified the applicant's rep of their need to provide an updated, accurate survey depicting all of the full compliance with New York State DEC order on consent. We need that in order to complete our review. Additionally, the survey indicates several other encroachments. There are two masonry walls, or masonry columns rather, into the town right-of-way on Nadia Court to the west. There's a paved driveway curved into the town right-of-way on Nadia Court to the north. There's a portion of the irregular stone wall on the property to the north. And lastly, there's a portion of the metal fence on the property to the south and into the scenic easement to the east. DEW recommends that all such encroachments be removed prior to any approval. And we wish to consider any information presented by the applicant, as well as any comments received from the public before making a recommendation to the board. Therefore, no decision will be made tonight. Thank you.
All right. Okay,
Understood.
thank you. Is there anyone in the audience like to be heard on this application? Can I have a motion to close the application, please?
So moved.
Second.
Motion has been made to close the application. It's been seconded. All in favor?
Aye.
Motion carried. Thank you.
Thank you. Good night.
We're just going to take a 5-minute break before we start.
Case on the agenda. Case number 18830, Charles Muller, 7 Seashell Lane, Fort Salonga. The location of the property is the northeast corner of Marion's Lane and Seashell Lane. The property is owned R43. The applicant is requesting certificates of existing use for 3 single-family dwellings on a lot without separate road frontage. A variance that any structure used for a lawful use shall not be repaired, reconstructed, or structurally altered to the extent exceeding 75% of the fair market value of the structure. To increase the gross floor area of a lot within the LWRP from 6,549 square feet to 8,957 square feet for 3 single-family residences, 2 detached garages, 1 shed, and 1 pump house, per a site plan submitted to the Planning Department dated November 22nd, 2022. To permit environmentally sensitive lands to be altered. To reduce the setback from the flood hazard zone from 10 feet to 0 for existing structures. I'm sorry, that's supposed to be from 100 feet to 0 for existing structures. An interpretation of Town Code Section 322-29 for the calculation of maximum gross floor area within the local waterfront revitalization program to include environmentally sensitive land, and an interpretation as to whether the 3 single-family dwellings on the lot constitute a prohibited or non-conforming use. As if it is not non-conforming, Town Code Section 322-73 would not apply, and a certificate of existing use would not be required.
Good evening.
Good evening, Mr. Chairman, members of the board. For the record, Philip Butler with the law firm Farrell Fritz on behalf of the applicant Charlie Muller. Mr. Muller is also here with me this evening. I'll apologize in advance for the length of my remarks, but as this board will recall from the last hearing, there was quite a lot of public comment, which I think warranted a pretty extensive response. So as the board knows, this application seeks to legalize 3 existing single-family dwellings that predate the town zoning code and certain other conditions on the property. This application was previously before this board on December 13th, 2022, on which day Mr. Muller, his supporters, and I set forth our reasons for why the board should grant the application as presented. Also at that hearing, several members of the public made comments on the record that warranted a thorough response. One such commenter was attorney Timothy Hill, who asserted that this application was not properly before this board for certain jurisdictional reasons, and that the application was improperly noticed for failure to expressly seek the interpretations. In light of the public comments received and the fact that this board was not in a position to render a decision because of the status of SECRA, we requested an adjournment and ended up with today's date. During the break in the proceedings, my client and I decided to amend his application to explicitly request the interpretations, notwithstanding that we disagreed with Mr. Hill's legal opinion. Consequently, this hearing was carried over to today's date and was duly renoticed in accordance with the town and the town law's requirements. With respect to the requested interpretations, Mr. Muller appeals from the building director's interpretation that Section 322-73 of the zoning code requires Mr. Muller to obtain certificates of existing use for the 3 residences on his property. The reasons supporting this appeal were set forth at length during the first hearing on December 13th, and again in the written submission that accompanied the amendment submitted to this board on May 4th, 2023. In the interest of time, I will not restate all of those arguments, but I ask that this board please review the record and the written submissions and give due consideration to those arguments. But summarily, we submit that the board should conclude that the residences on Mr. Muller's property are not, quote, non-conforming uses, as that term is defined in Section 322-3 of the zoning code. Accordingly, the building director's interpretation that certificates of existing use are required should be reversed. Additionally, Mr. Muller appeals the building director's interpretation that the maximum gross floor area for all structures on his property is 6,549 square feet, or 2.36% of his 277,000 square foot property. The building director reached this unduly harsh result by applying two overlapping sections of the zoning code to the same property. Specifically, he applied section 322-19B and 322-29, and in effect performed a double deduction for the same environmentally sensitive lands. Mr. Muller and I offer a more reasonable interpretation of the zoning code, which again was set forth in our prior presentation, and I will not repeat it here. However, we submit that the board should find that the maximum floor area for Mr. Muller's property is in fact 16,863 square feet, which still represents only about 6% of Mr. Muller's total land area. If the board rejects either or both of Mr. Muller's appeals for the stated reasons that follow, we respectfully submit that the board grant the relief from those sections, in addition to the relief from sections 322-19, C, D, and E. As to comments received at the prior hearing from attorney Timothy Hill, he argued that this board cannot entertain this application because the prior lawsuit that concluded in 2018, matter of Niger versus Benz, has a preclusive effect on Mr. Muller's appeal. This is legally incorrect. First, there have been changes on Mr. Muller's property subsequent to 2018 that require different relief than was sought in the prior application. This is not the same exact application, even if there is common relief between them. Even if this were not so, the court in matter of Niger expressly left the door open for further application by Mr. Muller, reversing this board's prior decision, which granted the variances, including the certificates of existing use. The court wrote, settled judgment granting the petition and annulling the determination, quote, without prejudice to supplement the record and make a new determination on the issue of certificates of existing use. I'll hand up a copy of the decision when I'm done presenting. When Mr. Muller came back to the town following this decision, he was instructed to file a new application in order to proceed further. That is what Mr. Muller did, and that is how we are here today. Nonetheless, the assertion that Mr. Muller is precluded from bringing this application is contrary to the express decree of the deciding court in Niger. Mr. Hill also asserted on the prior record that section 322-83D of the zoning code precludes this board from granting Mr. Muller the full relief he requires. That section states that board cannot grant more than 3 variances for lots having substandard frontage or area. Neither is the case here. In the R43 zoning district, the minimum street frontage is 40 feet. The minimum lot area is 43,560 square feet and 43,560 square feet per dwelling unit. Mr. Muller's property has 305 feet of frontage and more than 277,000 square feet of land area. Notably, the building director did not identify section 322-83D as one of the sections requiring a variance, despite direct inquiries from my office regarding the application of that provision to his property. Even if the building director did direct Mr. Muller to seek relief from that section, this board would be authorized to grant relief from that section as it would any other section of the zoning code. Finally, Mr. Hill asserted at the prior hearing that pursuant to 322-73C of the zoning code, the expansion of the existing residences by Mr. Muller's predecessors, the Longbothams, negated any status that those structures had as pre-existing uses. Nothing in that section of the code supports this contention. In fact, the code says the opposite. Section 322-73E expressly permits the expansion of pre-existing non-conforming uses under the proper showing. In any event, as previously stated, Mr. Muller submits that none of the residences is a non-conforming use as defined in the relevant section of the code. And in the event the board rejects that appeal, Mr. Muller has applied for the appropriate relief for the expansion of the residences. Moving on to other comments received at the prior hearing. It was previously alleged by Mr. Hill and others that the residential use of certain residences on his property had lapsed. The use of the residences for that purpose has never lapsed. The town zoning code defines use as, quote, any purpose for which a building or structure or part thereof is arranged, intended, or designed to be used, occupied, maintained, made available, or offered for use. In other words, the actual use of a building or structure is not required to establish or maintain a specific use, provided the building or structure is, quote, arranged, intended, or designed for that purpose. Here, the residences on the property have always been arranged, intended, and designed for residential occupation, even if not continuously occupied. On February 17th, 2023, Mr. Muller's predecessor, Orrin Longbotham, sent an email with additional details regarding the property's history. In it, Mr. Longbotham states that the Beach Cottage, or Peter Pan House, is a 1904 Montgomery Ward prefab summer cottage. As of his earliest memory of the cottage, in 1953, the cottage was livable space that included a kitchen, bathroom, and fireplace. It was not a shack consisting of 4 walls and a roof, as claimed by one resident at the prior hearing. It was a seasonal residence. This information will be corroborated by Mr. Muller's contractor, Mr. Leon Pugh, who renovated the cottage and viewed its original condition. Mr. Longbotham further stated in his email that the brick house was also never unoccupied or uninhabitable. He stated that, quote, "The brick house was never unoccupied, always opened each summer. Our family made a decision in the late 80s to board the windows and doors in winter months due to an increase of curious local youth entering for their mischief. It was always used and opened each summer, becoming our family's full-time residence in 2001. I'll provide a copy of Mr. Longbotham's email at the end of this. There is nothing before this board suggesting that either of the residences was ever arranged, intended, or designed for a non-residential use. Thus, the quote-unquote use of the residences for residential purposes has been continuous, even if not continuously occupied. There is no question that Mr. Muller has continued the residential use of the premises since his purchase in 2013 by, among other things, investing significant time and money in maintaining the residences for residential occupation. Another allegation at the prior hearing was that Mr. Muller is using his property for commercial purposes. He is not. The garage adjacent to Seashell Lane on the premises is not being used as a place of public assembly. It is not a quote-unquote dance studio or a music venue, and it has never been operated as such. Mr. Muller is and will continue to use his garage as additional recreation space and for social gatherings. Yes, Mr. Muller is a musician, and he enjoys inviting musicians and friends over to play music. That does not transform this space into a music hall. Nor is Mr. Muller using that space for a not-for-profit. Mr. Muller previously wished to host meetings of his grassroots environmental group, the Salonga Wetlands Advocates Network, or SWAN, at his property. However, that plan was discontinued with the pandemic. He has not revived it and has no current plans to do so. In any event, it is quite a stretch to describe philanthropic gatherings as commercial in nature. By that logic, meetings of civic and neighborhood associations are also commercial. Certain of Mr. Muller's family members previously used the garage to host yoga and physical fitness classes. However, that use has long since ceased and will not be continued. Finally, none of the residences on the premises are being used for short-term rentals. The prior use of the beach cottage for that purpose was temporary, but in any event has been discontinued at the town's direction. Mr. Muller is also not using his property as a public park. Again, before the pandemic, Mr. Muller expressed a desire to open his property to SWAN members as a means to encourage appreciation for the local environment and to boost enthusiasm for local conservation. However, that plan also did not come to fruition, and Mr. Muller has discontinued it. He has no plans to use his property for a public or quasi-public purpose. But even if Mr. Muller did propose to open his property to friends or associates of his environmentalist group, that activity has no relation to the legalization of the existing single-family residences or the other relief Mr. Muller is seeking by this application. At the hearing, other assertions were made about Mr. Muller's activities threatening the water quality in Fresh Pond and the safety of various animal species allegedly observed there. These assertions are purely speculative. The resident who made them cited no evidence of water quality contamination emanating from Mr. Muller's property. There are 20 other properties fronting on Fresh Pond, all of which have the potential to contribute stormwater to the pond. To the extent certain structures or improvements on Mr. Muller's property may not have up-to-date drainage, it bears in mind that Mr. Muller is not responsible for the work completed by his predecessors, and even if he were, the issue of drainage can be addressed prospectively, to the extent there is a genuine need for it. It is not a basis to deny Mr. Muller's application. If anything, denying the application would prevent him from making further improvements to the property, including drainage, if it is necessary. Allegations were made that Mr. Muller's driveway to his beach cottage is channeling water onto Seashell Lane. This is also speculation. Notably, there has never been a complaint filed with the town about this condition. The resident who complained of it has submitted no proof of this condition, despite this project and this application pending now, I'll say 5 months, but realistically, it's been going on for more than 6 years. Moreover, Mr. Muller has advised me that the driveway in question was intentionally pitched so that any stormwater on it is sheeted off into the woods and does not drain down to Seashell Lane. Mr. Muller also is not seeking to subdivide his property. This was an option that was explored by others in the past and revisited by Mr. Muller as a potential path to legalizing the residences. However, it was discontinued based on negative feedback from the town. He has not pursued the subdivision option since, and there is no application pending to this board or any other for subdivision of the property. Finally, Mr. Muller has no application to install a dock anywhere on the property, but even if he did, the dock again has no rational relationship to any of the relief that he is currently seeking from this board. Turning now to the merits of Mr. Muller's application, this board concludes, if this board concludes that Mr. Muller does in fact require the CEUs for the existing residences, that relief should be granted. The planning department previously reported that their records indicate that the structures predate zoning, and copies of the town's own assessment records corroborate this representation and were submitted at the prior hearing. The question for this board then becomes what standard applies for the expansion of those dwellings, which was done by Mr. Muller's predecessors. In matter of Niger, the Supreme Court ruled that this board correctly applied the area variance standard to Mr. Muller's application, notwithstanding that section 322-73E of the zoning code states that a use variance standard should be applied when a nonconforming use is expanded. That court finding was never challenged. Nevertheless, to the extent the use variance standard is at all applicable, Mr. Muller meets the standard for the following reasons. First, the existing dwellings on the property cannot be used for any other purpose allowed under the existing zoning other than single-family dwellings. The Residence District Table of Use Regulations lists all permitted and special permitted uses in the R43 district. Notably, one-family dwellings are permitted. Any other use is infeasible because it would be impractical, or it would change the use or intensification of the property, or both. Therefore, if Mr. Muller is forced to cease the use of any of the existing dwellings for residential purposes, there will be no other viable purpose, and the building will effectively be valueless. Consequently, he would be unable to realize a reasonable return on his investment when he acquired the property. This information will be corroborated in a moment by the testimony of Mr. Howard Morris, who is a real estate appraiser with more than 19 years of experience in the field. Second, the hardship in question results from the fact that Mr. Muller owns a single lot that is improved with 3 freestanding dwellings, each of which existed before the town zoning was enacted. No other property in this district or neighborhood is known to have the same condition. Therefore, the hardship is unique to Mr. Muller. This fact will also be corroborated by Mr. Morris, who conducted a survey of properties in Fort Salonga as part of his investigation of Mr. Muller's property. Third, the variances are sought in order to maintain the existing residences in a predominantly residential district. But for the fact that all 3 dwellings are physically located on the same lot, there is nothing about their respective use that sets them apart from the surrounding district or neighborhood. Indeed, the dwellings have been used for residential purposes without issue since their construction. Therefore, a decision by this board allowing the dwellings to remain will not alter the essential character of the neighborhood. This fact, too, will be corroborated by Mr. Morris, who compared Mr. Muller's property with numerous surrounding properties, which he found to be indistinguishable but for the fact that Mr. Muller's property is a single lot. Moreover, Mr. Morris will offer testimony to the extent that Mr. Morris will offer testimony to the extent that Mr. Muller's property will have no negative impact on adjoining property values if used solely for residential purposes. Anecdotally, it is notable that one of the expanded residences, the Brick House, has been recognized as a, quote, cultural asset by the town in its proposed LWRP amendment. Arguably, the preservation of a cultural asset through adaptive reuse is only a benefit to the value of surrounding properties. Finally, as previously indicated, the town's records confirm that each of the existing residences predates town zoning. The subsequent improvement and expansion of those dwellings by prior owners predates Mr. Muller's ownership and his control of the property. Therefore, the hardship he faces is not self-created. That Mr. Muller perhaps knew that there were potential issues with the property before he acquired it, as alleged by one of his neighbors, does not mean the self-created hardship is, self-created hardship is actual. Mr. Muller reasonably believed that any purported issues with his property could be remedied through appropriate approvals through the town, which he availed himself of seeking. These issues existed, again, before Mr. Mueller came into the picture, and he is simply the one cleaning them up. I would like to call up Mr. Howard Morris now to summarize his professional findings for the board. Mr. Morris is an accredited real estate appraiser with 19 years of experience in the field, and he is also a real estate salesperson. He has also served as an expert witness in several court cases involving the valuation of residential property. He will speak to the highest and best use of Mr. Muller's property, the viability of other permitted uses under the R43 zoning, and the property's impact on the value of surrounding properties. And I will hand up a copy of his CV when I'm done with my presentation.
Thank you. Good evening.
Good evening. I promise I will not take as much time.
Great. You just state your name and
Sure.
address.
Howard Morris, Rogers and Taylor Appraisers. 38 years of experience, but who's counting? I was asked to go out and walk the property at 7 Seashell Lane, get a feel and sense of what's there. It's very hard to look at a survey and know exactly how everything kind of lays out. Went and did a site visit, walked the property, and when you walk the property, you get a sense. 6 acres is a lot of land. There, as Phil mentioned, there aren't very many 6-acre properties left, around almost anywhere on the North Shore, unless it's in specific 5-acre type zoning. Here we're in an R43 zoning. I mean, theoretically, you go, all right, R43 zoning, the property could be subdivided. Our client is not interested in subdividing property, is interested in using it the way it is. So in looking at highest and best use, my first action is, can the property be subdivided? If the client doesn't want to subdivide it, wants to use it as is, does the property conform and does it make sense? What's on there makes sense. There's a cottage up front by the water, there's a main house, and on Marion's Lane, there's a ranch-style house that's on the pond. If you were pulling into the driveway, I'm sure many of you have probably gone and looked at the property, to the left of the driveway, you would not know that what is addressed as 28 Marion's is actually part of this property. It sort of stands on its own. The houses, if you think of it this way, each house occupies a little over 2 acres of land for each piece. I looked at a lot of the properties in the surrounding area. And there are some properties that are a little bit larger than the acre. The vast majority of property in the area is on the R43 zoning. And there, in many ways, a lot of the properties have much more substantial improvements on them than what is on this property. The main house, the cottage, and this structure we're looking at here, they're not substantial homes. And what we're seeing happening in all of the areas on Long Island is a lot of the redevelopment of property. And these homes are properties that were built 1850, 1904. They've been around for a long time. So it kind of makes sense that they should have the proper existing uses, and that they do, in fact, conform to the community. I think there was one other note that I had in walking it and researching it was that you probably have a lot of people that stand up in front here and talk about are requesting subdivisions of properties that are barely the 2 acres, and they're looking to get 2 lots. And that's why over the years the prior owners, they kept this all one lot, and by doing that, they've preserved 3 structures on a single 6-acre lot. And from my perspective, for a 6-acre lot, what's on this structure more than conforms to the community, and it doesn't offer any negative impact to neighbors and to the community. I'll leave you with that.
All All right, thank
Thank
you.
you.
I would like to call engineer Matt Aylward of R&M Engineering. Mr. Aylward will speak about some of the content that Mr. Morris just spoke on regarding the potential uses of the property, and also wants to provide an update on some environmental diligence that was requested at the prior hearing.
Good evening.
Good evening. Matthew Aylward, R&M Engineering, 50 Elm Street in Huntington. Last name is Aylward. At the last hearing, there was a request for an updated soil boring. The previous boring was dated in 2007. Our office went out today, dug a new test hole to confirm the soil composition, and we found that it matches the 2007 boring, which we expect because there was no significant ground disturbance or soil replacement. What we did find was that the groundwater elevation was 12 inches lower than what was on that 2007 boring. Now, we can kind of anticipate that. It's been pretty dry for the last week and a half, 2 weeks. So what we believe is by utilizing the 2007 boring, those groundwater elevations to determine the contours and sensitive areas, we believe that's a nice conservative approach to stick with in this case. Also, in terms of what Howard Morris had said, we agree with his remarks that the current uses, the 3 residences, are consistent and actually are the most appropriate uses of the property from a zoning and engineering standpoint. Other permitted R43 uses would be more impactful on the properties in terms of sanitary density, infrastructure requirements, and even traffic generated by those uses. If you have any questions, I'm happy to answer.
At what depth did you hit groundwater?
The depth on the boring in the 2007 boring was 3.7, which was elevation 5.2. We hit it at elevation 4.3.
4.3.
4.3.
Okay, thank you.
Okay, I would like to call Mr. Leon Pugh, who will speak to the condition of the beach cottage prior to its renovation.
Good evening.
Hello, how are you? My name is Leon Pugh, P-U-G-H. I'm the owner of 5 Star Plumbing and Heating. I've been in business for about 25 years now. And Mr. Muller hired us to do some work on the beach house. And it's basically was all existing plumbing for a kitchen, bathroom. We basically just refurbished what was existing. Nothing was added, just brought up to date. The sinks were relatively old, cast iron, dating back to the 50s. It's a beautiful little beach cottage. We did a great job, and I'm just here to state the fact that everything was existing. Nothing was added, and things like that. I think that's all they needed from me, right? Yeah. Thank you.
All right, thank you.
Yeah, 5 Star Plumbing, you knew. Yeah, 5 Star Plumbing, you got that now.
Right.
Okay. Before I turn this over to my client for his prepared statements and also for his wife, Tia, I just want to impress upon the board that, that we've attempted in good faith to address the issues that were raised at the prior hearing with the neighbors who spoke and who I anticipate will be speaking again this evening. One of the reasons that I adjourned this matter was to provide my office time to meet with Mr. Timothy Hill and his clients and try to reach an amicable resolution for any of the legitimate issues they posed at the prior hearing. After speaking with Mr. Hill on one occasion in or about March of this year, I never heard from him. Despite repeated calls to his office, during which I left voicemails asking for him to call me back, I received no response. Unfortunately, I take Mr. Hill's conduct as an indication that neither he nor his clients have any indication of working with Mr. Muller in any capacity. Inasmuch as that is their choice, I believe it must be noted for the record that we did make an attempt. With that said, I will turn this over to Mr. Muller. He has some words for the board, and then I will conclude.
All right. Good evening.
Good evening. Charles Muller, M-U-L-L-E-R, 7 Seashell Lane, Fort Salonga, New York. Good evening, Mr. Chairman, members of the board. I was surprised by the 40 false statements made at the December 13th hearing by a few neighbors who opposed my variance application. I was surprised because in the 10 years since I've owned the property, none of those neighbors has ever come to me with a single complaint about anything. Suddenly, I'm falsely accused of conducting commercial activities and hosting illegal public events, causing home invasions and harming the environment. And not to my face, but to the zoning board and to the public and to the press. I have since reached out to these neighbors through my attorney asking what they want. They have not responded. 9 years ago, when I started my application process the first time, I asked Mr. Piskors what he wanted, and he said, "I want everything to stay the same," quote. And that's what we're asking for. These neighbors have attacked my character. Although their defamatory public comments were completely irrelevant to my application, I can't let them go unanswered. I have to clear my name. The comments are shocking, not only to me, but also to my family and our friends, especially the many who live in our neighborhood. And you see how many supporters we have here tonight. I've been a law-abiding Fort Salonga resident for 39 years. I try to be a good neighbor. I pay neighborhood road association dues even though I'm not required to, but I use the roads, so I pay. I loaned the neighborhood $80,000 to save neighbors the hardship of a large assessment when the roads needed repaving. I co-founded an environmental nonprofit to advocate for Fort Salonga's wetlands. And my wife and I are committed to revitalizing and protecting Fresh Pond and the historic Longbotham Lower Farmhouse, where we live, a residence that is listed in Smithtown's LWRP draft as a cultural asset that needs to be protected to benefit the community. I have not conducted commercial activities on my property. There has never been a, quote, physical therapy, dance, fitness studio business, unquote, located there. The photo Mr. Piskors submitted was taken 8 years ago without my permission and without telling me he objected. When my youngest daughter had friends come to our home to help her develop her yoga and fitness training skills. She did successfully launch a business, but not on our property. She started a yoga studio in New York City and now contributes to our local community's wellness through her studio in East Northport. Her business was never located on our property. And our barn is not a, quote, music venue. It's an unfinished garage where friends and family get together to play music, which no neighbor has ever complained about. Our environmental nonprofit has no employees or offices, and we have not held any public events on my property. My wife and I hosted 2 private gatherings to benefit the environment. The first was in 2019 and included neighbors and friends, many who are here tonight, by invitation only. Eva Starks claimed that they, quote, "They come from across Long Island, who they are, unknown, scouting the neighborhood for possible mischief," unquote, is false. They were neighbors and friends who spent the day learning about Fort Salonga's wetland challenges. The other gathering was 2 years later. It again included neighbors and friends by invitation for a beach cleanup. Ms. Stark's statement that we illegally held the event without the proper permits is false. I contacted the town in advance and was informed that no permits were needed. And no neighbors complained as we cleaned up 120 pounds of garbage from the beach in front of their properties. Aside from those 2 gatherings, we have hosted 5 large family parties in 10 years, some with live music, and again, no complaints from the neighbors. No one associated with my property has ever trespassed on Ms. Stark's property or invaded her home, and she has never contacted me about this issue. Everyone has the right to use the beach in front of her bulkhead and ours up to the mean high water line, and it is accessed by people who walk the shoreline from Mackinac Beach and from Callahan's Beach and Sunken Meadow Park and from neighboring homes and beach access easements. Mr. Piskors made a series of false statements in the hearing that portrayed me as a threat to the environment that I work to protect, and he never previously mentioned any of those concerns to me. For example, quote, Mr. Piskor said, quote, "To this day, he has not implemented any of the environmental conditions from the previous variance ruling," unquote. That's false. I installed the required flood vents in the barn, flood vents. I hired an engineering firm to design the required rain gardens, which were approved by the DEC. However, during that time, as we all know, Mr. Hill, who represents Mr. Piskors, appealed the ZBA's variance ruling, which led to the variances being completely nullified, making it illegal for me to move forward with the rain garden construction. Mr. Piskors also said, quote, "Since the last hearing, the applicant has completely renovated the beach cottage, adding plumbing, heating, air conditioning, kitchen, bathroom, and a washer dryer," unquote. That's false. The 1953 tax assessor's schedule that we submitted to the board clearly shows the existence of a bathroom, and we also know that the beach cottage had electricity, plumbing, propane tanks, a hot water heater, a fireplace, a kitchen with a sink and a stove, a bathroom with a sink and a toilet and a shower. Those fixtures all needed updating when I arrived in 2013, as they were at least 60 years old, a fact that Lauren Longbotham recently confirmed in writing and that Mr. Pugh attested to. I updated the cottage, making it safer and more energy efficient. As the work was being done, a town inspector came by at the request of an anonymous neighbor, and the inspector did not issue any violations because no permits were needed. Mr. Piskors also said that I, quote, "added a 250-foot paved driveway with no drainage. These things were done with no regard for proper water drainage." That's false. I specifically directed the paving contractor to grade the driveway to drain into a low wooded area. Also, the driveway is less than half that long. The work was done 6 years ago, and I have received no complaints. Mr. Piskors also said, quote, "Water runs down the driveway and completely floods out Seashell Lane, making it unwalkable." That's false. I have been monitoring the stormwater flow for 6 years and have several videos that clearly show that Seashell Lane floods itself. Rainwater that falls directly on the 1,000-foot-long, low-lying road has nowhere to go, so it flows to the low area in front of Ms. Stark's house. Mr. Piskors also said, quote, "He continued to build on this property, causing more environmental conditions," unquote. That's false. I have built nothing. Mr. Piskors also said, quote, "All these things create environmental issues," unquote. That's false. I have created no environmental issues. In fact, my wife and I are working to help solve environmental issues through our nonprofit. Ms. Stark made a series of false statements that portrayed me as an inconsiderate neighbor and a lawbreaker. I had reached out to her 6 weeks before the first hearing, and I asked if she had any concerns. We discussed each variance in detail, and by the end of the call, I thought she had no concerns. And she did not mention anything about commercial activities, public events, invasions of privacy. Forgive me for my attitude. I'm
Just address the board,
a little
please.
upset. Yeah, I apologize. So I was surprised when Ms. Stark showed up at the hearing and made 14 false statements about such concerns. I have already mentioned some of Ms. Stark's false statements. Others include, for example, quote, "Over the years, he increased the size of each building, adding a bathroom to the beach house." Those are false. I did not increase the size of any building. I did not add a bathroom to the beach house. Ms. Stark also said, quote, "He enlarged the tiny shack and made it into a large building, more like a garage," unquote. That's false. I did not enlarge any buildings. Just two more from Ms. Stark. Quote, "Mr. Muller desires to commercialize our community," quote, unquote. That's false. I have no desire to do that. I am aware that my property is zoned residential, and I am not applying for any commercial rights. Finally, Ms. Stark also said, "Mr. Muller desires to change our community," and that's false. My wife and I are preserving historic farmland and the 3 oldest houses in the neighborhood, while surrounding homes are being demolished and replaced with mansions. The purpose of our variance application is to keep everything the same. I could go on, but I'll stop there. The bottom line is these people are falsely attacking my character because there is no valid legal argument to contest the right to certificates of occupancy for legal dwellings that were built 75 years ago, 114 years ago, and 170 years ago, each on over twice the acreage now required by 1 acre zoning, and which enhance the character of the neighborhood and the value of surrounding properties and do not infringe on anyone's rights or the environment. My wife and I are asking only to have normal residential rights to these pre-existing, modestly sized, well-cared-for houses and the related outbuildings. I appreciate the time you've allowed me to address my neighbor's false and irrelevant comments. Please let me take one more minute to highlight 3 important points. First, we discontinued last year's beach cottage Airbnb rentals after being informed that they're no longer allowed in Smithtown. Complaints neighbors voiced at the previous hearing, none of which ever were mentioned to us, are no longer an issue. For the record, we had registered the rental with Smithtown. We paid taxes on the revenue to Suffolk County, and we never allowed a guest to stay with us who would intentionally bother a neighbor or ourselves. We live here too. Our guests were educated, refined people of means who had favorable prior reviews and who knew that an unfavorable review would severely limit their ability to rent through Airbnb anywhere in the world. Second, the Longbothams never discontinued the use of any of the houses as dwellings. I'm going to skip that paragraph. I think Mr. Phil covered that well. And third, I did not self-create the difficulty. I just want to say there's a difference between, and you know well, forgive me, between creating a difficulty and taking on the responsibility to remedy it. And by the way, in response to another of Mr. Piskor's false statements, I did investigate what I was getting into when I bought the property. I met with Frank DeRubius, the Smithtown planning director at the time, who advised me that my plan to legalize the existing buildings was reasonable. His only caution was that I should exercise restraint, which I have done and I will continue to do. And finally, the environmental amendments that have been mentioned, they slashed the allowable building floor area of the Longbotham family's pristine North Shore waterfront property by 41,255 square feet. That represents arguably $5 to $10 million in value at today's prices. We trust that this board will not cause that same legislation to now add insult to injury by denying these pre-existing houses their right to remain. My wife and I respectfully request the board's approval. Thank you so much.
Thank you. Good evening.
Good evening. My name is Tia Bonacore Muller. That's Bonacore. Last name Muller, Muller, 7 Seashell Lane. I am a full-time resident along with my husband, Charles J. Muller. Let me just say thank you to the board for allowing me to speak. I've been waiting 5 months for this. And I'm also truly grateful for the amount of support that we've received over the past few months. And it's obvious tonight with the amount of support that we have here from our tight-knit community. Fort Salonga really is a great place to live, and these families know us. They really do. So I won't allow a few naysayers steal my smile. I'm just really grateful that they're here on a day like this, on a Tuesday, to support us. So I just want to start with that I live in a historic 1850 farmhouse. It was built 173 years ago. The original brick is from the old brick factory at Fresh Pond. That brick is still strong. It looks amazing. We live with it every day. We have the original stairs in the house, and they're still engraved with the builder's initials, OWL. and anyone who has an appreciation for carpentry, when they come into our home, they admire the stairs and say they were so well built, they could probably last another 100 years or so. And our roof is pitch perfect, and it still has hand-carved designs, and there are no leaks ever. And there's also original milk glass above the old door that we still have, and I had someone look at it, and there's not a crack in it. And I'm telling you these details about our beautiful farmhouse is because it was well maintained. So whether or not the prior owners lived there just for the summer and boarded it up, or they lived there for the whole year, is really irrelevant, because the house, well, it was never abandoned. How could you say that about my house? They always paid their taxes, and we have proof of that. So you have to really love history when you live in a house like this one, not just because it has a lot of character, but both my husband and I just really enjoy historic preservation, and that's what we'd like to do. We'd like to keep this a part of history where children from the neighborhood can come and visit and learn about the past. It existed before cars, you know, and our piece of property looks a lot like it did in 1850. Besides our mutual love of old houses, my husband and I, like he said, are both environmentalists, and we take this very seriously. We both volunteer our time with Save the Sound. They're a wonderful organization from Long Island all the way to Connecticut, and Charlie and I both test the water quality at Nissaquag and also Fresh Pond. So if we see something happening there, we get in and drop a sonde, and it's very technical. He does more of the science and the math, and I assist and take photos. But we love Fresh Pond. I'm also an active member of the Audubon Society. I really love birds, but for the sake of time, I won't name them all. My husband and I, we consult with the Long Island Native Plant Initiative, another great organization, and we work hand in hand with them whenever we want to plant something, like a tree or native grasses, and that's been a lot of fun. The past 2 years, we've put in quite a few trees and shrubs that are only going to enhance the beauty of the property and also be beneficial to the wildlife there. But every time I plant a seed or a shrub or a tree, I think of our daughters. Because this property will belong to them someday, and I hope, God willing, our future grandchildren. That makes me very happy. I'm an avid organic vegetable gardener. Anyone who knows me or has been to the property has seen where I grow vegetables. And I don't just do it to feed my family organic food or my chickens. I donate the excess produce every week to Long Island Cares, the Harry Chapin Food Pantry, where I work. And for 2 years, I've been serving U.S. veterans. They're on Tuesdays, and Fridays, it's families and senior citizens who are facing food insecurity. And I know I will always have fresh food and enough to share. So that's part of, you know, what I'm passionate about. I have chickens, only hens, no rooster, and they lay fresh eggs every day. So I like to share that with the community and friends that come and stop by. And they had a chicken coop back in the 1800s, and we have pictures of the old farm where they had sheep and pigs. I'm not getting pigs, and I'm not getting goats, so don't worry if they're neighbors here. My mother's here tonight, and I'm so grateful for that. And she did teach me, if you don't have anything nice to say about someone, please don't say anything at all. So I will use restraint. But my father, who has passed away, was a U.S. Marine, and he taught me not to be intimidated by bullies. And our opponents who spoke at the last hearing, I was so outraged at all those false allegations. They do not know me. They have never met me in person because I don't see them outside, walking around, They don't come to our house and knock on my door. How could you say a thing about someone's family? And this is the house that I love so much. And I love my neighbors here tonight. And, you know, my husband just does not deserve to be slandered like this. He's always calm, and he's a logical thinker. And he's probably the most considerate person I've ever encountered. I won't get emotional. True, the only truthful thing that the opponent said at the last hearing was that he does like music. Wow, okay. Well, I love my home, and I would never consider leaving because of our daughters. I don't want to move. I don't want to subdivide. I don't want to modernize. Isn't it strange that I don't want to knock down an 1850 farmhouse and put up a McMansion with a pool? I have a view of the pond. It's gorgeous. I have everything I've ever dreamed of there. And they think, Lenny Piskor's thinks, or he said to my husband anyway, when asked, what would you do with this property? He said, let me get my bulldozer. Think about it if someone said that to you about your home, where your children are sleeping. Let me get my bulldozer. That speaks to his character. To wrap it up, we're only asking for the board's approval because we believe that we deserve the same rights that our neighbors have. Our house existed in 1850, and it exists today. It was always a home, and it never posed a threat to the environment. It stands as strong and as beautiful as the day it was built. I will never give up fighting for my home, and I will never give up fighting for my family. And I just thank you for your time.
All right, thank you.
So I appreciate the board's time. I understand this has been a lengthy presentation, but I think given the history of the application, the board probably understands why we are creating the foundation we are. We're hoping this is the last time we have to come before this board seeking the relief that we're seeking. My clients really just want to continue to be good stewards of the property, as I think was just made very clear. And this approval, if this board is so inclined, would allow them to do that. Without it, we're going to keep circling endlessly in this legal process, which I don't think benefits anyone, frankly, even the neighbors who are opposed to it. So with that, I'm going to conclude our presentation and open it up to the board and members of the public. I am going to hand up 4 items that I'd like included in the record. The first is the 2018 court decision, which I referenced earlier. The February 17th email from Orrin Longbotham. The qualifications for Mr. Howard Morris, our real estate appraiser, and a written report that Mr. Morris prepared. Thank you very much.
Thank you. I have a question for you. The existing structures on the property right now, how are they being used?
All 3 are being used as residences. Mr. Muller resides in, I always confuse them, the farmhouse, the lower farmhouse, right? And then they're going to have a long-term lease in another home. And then, Mr. Muller, I'm sorry, I don't recall. Oh, and they have a tenant in the was it 26 Marions? 28 Marions, excuse me. So all 3 are being used as single-family dwellings.
All right, thank you.
You're welcome.
Don't go anywhere. Let me find out if anybody has any questions for you. Anyone on the board have any questions?
I believe it was stated at a prior hearing, but what was the approximate date of the construction of the one-story frame garage?
Which garage? Because there are 2.
The 40 by 30, 1,200 square foot?
That's the one in the center of the property? What was the original construction date? Do you wanna come up?
My understanding is that there's an original barn that predates the zoning laws.
Right. So there was an original barn there, and it was converted into a garage. So the original barn predated the zoning.
So in your, actually it's probably better for Mr. Morris, would be when that structure was rebuilt. Is Mr. Morris?
Muller.
No, Mr. Morris, the appraiser.
Well, you're asking a historical question about the property?
No, it has to do with value.
Oh, okay.
Thank you, sorry for the confusion. So I guess Mr. Muller is stating that the garage replaced the former barn, correct?
Okay.
Was that barn, if it was improved, in your estimation, was the improvement in that barn more than 75% of the value of the prior barn?
Of the existing structure, the existing barn?
Correct.
No.
No, okay. And then the only other question I had was, there's another garage, I believe, is the other garage the one close to I don't know what you're calling them, the beach house or the cottage?
Yeah, there's a garage next to the cottage, that's correct.
Approximate construction date of that garage?
That also predates the zoning. You can see it on the aerials. I don't have an exact date. But to the point that I think you're making about the 75% value, that provision relates to obtaining a certificate of existing use. We are not seeking a certificate for the garage.
I'm just trying to cover all our bases
Okay.
here. Since there's so much being asked for on that call of the meeting, I want to make sure if the conversation comes up that the question's been asked.
Right, and that specific provision, again, pertains to expansion of a non-conforming use. The garage is actually permitted, so that wouldn't fall into the 75% increase in value provision. But I understand you're asking the question for sake of the record, but I'm just clarifying.
Okay, thank you.
Blaze?
Mr. Chairman, the Planning Department doesn't have anything further to add on the record regarding this case.
Sabrina?
Mr. Chairman, DEW will need to see the new test hole data in order to complete our review. Additionally, we wish to consider information presented by the applicant, as well as any comments received from the public before making a recommendation, so no decision will be made tonight.
Okay.
Understood.
All right. Now I'll open it up to the floor, and then you can come back and address their concerns.
Thank you.
Okay? Before we open it up, let's just go over some procedures, please. You come up one at a time, state your name and address for the record, spell your last name so we get it correct. Okay? If you spoke last time, everything is on the record. So, that would be great. But if you're just going to reiterate the same thing, it's on the record already. All right? So who wants to go first?
And they only get one chance.
The lawyer, please. Good evening.
Good evening, Chairman. Good evening, Board. Thank you for giving me the opportunity to speak this evening. I'm going to try to be as brief as possible. My name is Lisa A. Perillo. I'm with the law firm of Perillo Hill LLP, 285 West Main Street in Sayville, New York. My partner, Tim Hill, appeared here at the last appearance. He was also the attorney on the prior similar application concerning this same property back in 2014 or 2015, and he participated in the outcome of the litigation, which he successfully concluded. He wasn't able to be here today. We did request an adjournment so that he could be, but I'm going to put on the record our opposition in any event. We represent the Piscors, who are immediate neighbors to the subject property. They reside at 22 Marions. They're here today as well. Our clients and the various neighbors are here tonight to offer their comments for your consideration on this revised, new, amended application, whatever it is that's before the board tonight. I just want to touch on certain points of law, if I may. First, I want to cite that there's a lack of sufficient notice regarding exactly what kind of changed, new, additional, different relief is being requested in this amended application. It's not clear to me, reading the blurb of the call of this meeting. It certainly wasn't provided to my clients, who received spare notice about a change in the application with no detail whatsoever about exactly what relief was going to be requested. I propose to you that this application is confused. The applicant now indicates that he's seeking interpretations of the code, which are not interpretations at all. The way they're framed, from what I can tell, they're seeking code amendments changes in zones. They're asking for advisory opinions from this board as to how the code should be changed. They're also seeking a certificate of existing use if they need it, and apparently use variances if those are required, in addition to the area variances which they previously sought. All of these, cumulatively, together, confused. I want to focus on the fact that there's no clarity in what interpretations are actually being sought here. There's no identification in any of the notices we received as to what determination by the town is being appealed, such that your authority to interpret anything in the code is properly invoked here. There's no indication of what word or words are sought to be interpreted. Nothing is identified, and there's no indication of any inconsistency or ambivalence sought to be clarified or addressed here. Further, it's submitted that the notice is not sufficient because the interpretations, unlike other requests for relief, affect the application of the code broadly, not just to this property here. Only those who appeared at the last hearing and are possibly aware of the issues that we're going to be talking about tonight, and only those who are already here know what is being requested in these interpretations. As such, anyone else in the town that's affected by broad application of what you're interpreting, of how the code should apply, has not had sufficient notice about what's being discussed here. In addition, I submit that the applicant is asking for what's not actually an interpretation of the code, but again, a code amendment or an advisory opinion as to how the code should be changed as concerns what should be included in GFA calculations for environmentally sensitive lands. Applicant identifies no ambiguity in that code. He just doesn't like the way the code is being applied here, and he wants you to change it. That's not a proper request before this board. And with the other alleged interpretation that I seem to understand that he's seeking, they are apparently looking for an outright determination from you that the dwellings are legal non-conforming uses. That's not an interpretation of the code. That's a determination that the board must make if and only if the applicant makes a sufficient showing. It's their obligation to make that showing. They have to do that and meet their burden of proof pursuant to Town Code 322-77A. They cannot do an end run around that requirement, an intentionally high burden, because you want to discontinue non-conforming uses eventually, by couching this as an issue of interpretation when it actually isn't, and shifting the burden onto the board. Second, there is no final adverse determination identified by the applicant in the application or in any notice that we received from which they purport to take an appeal. I mentioned that before. And I refer the board code section 322-80 concerning the Board of Appeals interpretation power. You're authorized to make interpretations on appeal of the meaning of provisions of the zoning ordinance. Again, there's no identification of anything they're appealing. There's no adverse determination of any meaning of any zoning ordinance that's being applied here. That's not what's being asked of the board. In addition, the applicant improperly seeks to have this board reconsider the same request for relief that it had already been considered, decided by the board, and overturned by the Supreme Court. Mr. Butler's earlier limited reading of this case is incorrect. Pursuant to Town Code Section 322-81D, this board shall not hear an application to review an earlier decision concerning the same property. This board has already made a determination concerning CEUs requested on this very property. Faced with the same lack of evidence of continuous lawful nonconforming use presented in this application. They didn't make the showing then, they did not make the showing now, and that's what that case stands for. The case said on the merits they didn't make this showing. Applicant here makes no new sufficient showing as to the abandonment issue or as to the issue of prior existence of this current use. To make a finding inconsistent with the court's order now is inconsistent with Town Code 322-81D and the definition of unreasonable, arbitrary, and capricious. Third, even if it was properly considered, the applicant has not made and cannot make the requisite showing entitling him to the requested CEUs. Town Code 32277A provides that the board shall not issue a CEU if the ordinance requirements of the section are not met. Here, there is no showing, as there must be by the applicant, that the use was in full compliance with all relevant regulations at the time the zoning ordinances were adopted or amended so as to make the use or structures nonconforming. It doesn't matter that it was a long time ago. The use was not, and there must be a showing that the use was not abandoned for more than 12 consecutive months. There's been no showing, no evidentiary showing of the same. As such, that relief just can't be granted. Again, the burden of proof is intentionally high because the goal is to ultimately discontinue nonconforming uses because they don't integrate with the town's comprehensive zoning plan. There has been testimony, certainly at the last hearing, by long-term residents to the contrary. They have testified that the prior nonconforming use of the property was abandoned for the statutory period and that there was an unlawful resumption. And when that resumption happened, that use was intensified, expanded, and changed. I remind that this board is required to describe in detail the nature and extent of the lawful nonconforming use if it authorizes a certificate of existing use to be issued. I submit to you that the board cannot do this based on what showing has been made or lack of showing has been made by the applicant. Fourth, the applicant requests a relaxation of the zoning regulations applicable to environmentally sensitive lands. The LWRP GFA calculations specifically. It should be noted that pursuant to Town Code 32229A, because such a request impacts the overarching local waterfront revitalization program, it can't be approved, authorized, issued, or altered without the town board determining in writing, pursuant to Chapter 151 of the Town Code, that the action is consistent with the LWRP, policies, standards, and conditions. I don't see anything in the record that has been done. Without that first step, that application for that relief is premature. Even this notwithstanding, the request that the applicant makes, specifically that the method of calculation should be revised, is not a request properly before this board. Again, it's not an interpretation issue, it's a change of code. Fifth, the applicant does not make the requisite showing necessary for the grant of a use variance. You all know that's a very high burden. Indeed, even asking for a use variance here is an admission that their current use is an unlawful nonconforming use. Use variances require the applicant to meet the very heavy burden of showing the requisite elements entitled them to such drastic relief, and the applicant does not do that. The applicant does not show that it cannot realize a reasonable return on his property. This inability must be substantial and shown by competent financial evidence. I don't see that was had today. Again, a reasonable return on the property, not the absolute best return on the property, not the optimal return on the property, a reasonable return on the property. The applicant cannot show that the alleged hardship is unique and does not apply to a substantial portion of the district or the neighborhood. There's nothing really unique here. It's a residential lot that can be used for residential purposes. Any hardship is entirely self-created. The applicant cannot show that the requested variance will not alter the essential character of the neighborhood. It clearly will, and it is essentially a mixed-use compound in this quiet residential neighborhood. Further, the intense use is inappropriate for the environmentally sensitive land. Finally and fatally, for use variances, the alleged hardship is completely and entirely self-created. The applicant purchased this property full knowing its zoning issues, fully aware of the prior history, including the prior owner's attempts to get the certificates of existing use. And since purchasing the property, it's not really controverted that the applicant has added and expanded to the non-conforming use without the benefit of approvals or permits, as the neighbors will attest, as they already have attested. Thus, a use variance is not properly granted, if that's indeed what they're seeking. 6, the factors required to be weighed by the board in considering area variance relief, apparently still requested, weigh against the granting of said relief. It's clear that the requested relief will cause an undesirable change in the character of the neighborhood, as I already discussed. As you will hear from the neighbors, parking and traffic issues, visual blight, numerous structures, as well as drainage issues and flooding issues, all impacted by the increase in hard surfaces and steep slopes, essentially converting this environmentally sensitive property into a multi-use compound will change the change the character of the neighborhood. Further, there is no clarity on whether the benefits sought can be achieved by some method feasible to the applicant to pursue other than by variance. It's clear there are more than just area variances apparently sought, but what exactly is sought, that's unclear. It's also clear that the applicant has not made any attempt to consider any feasible alternatives to the requested relief. There's been no discussion of same. And the requested relief is clearly substantial. Applicant seeks to legalize extensive unpermitted expansion on already non-conforming uses. For example, there's 100% relaxation of the side yard setbacks for each of the houses on the property, an unquestionably substantial relief from the wetland setback, and 30% relaxation of the LWRP. And let's not forget that the application does also exceed the town's 3 variance rule. All of this will have a clear adverse effect or impact on what is already designated environmentally sensitive land, and broadly and physically to change the environmental conditions of the neighborhood. It'll impact the wetlands, it'll impact drainage issues, and flooding, as well as erosion due to the sloping on the properties. And as indicated previously, the hardship complained of is entirely self-created. The zoning limitations applicable to this lot were well known to this longtime Fort Salonga resident. I will note that there was a lot of reference to Mr. Hill's comments at the past hearing, comments from my clients and from other neighbors at the past hearing. All of that's really irrelevant since this is supposedly a new and revised application. I also note that the bulk of this hearing being devoted to the prior application is completely inappropriate, and there's been no showing regarding the new relief, whatever that relief may be. Applicants should not be rewarded for doing whatever he wants first and asking for approvals later, including thumbing his nose at the town zoning code and the town's interest in protected environmentally sensitive lands and wetlands. That's the town's job. It's not the private owner's job to protect the wetlands. That's why you have those regulations in the code. That's why you did an LWRP. That's why the state promotes that program. Finally, at the very least, we ask that this hearing be kept open so that we may submit written submissions in opposition to the new materials that were submitted today. Again, I reiterate that we did ask for an adjournment of this hearing because the notice was inappropriate and insufficient. We didn't really know what was being asked. We still don't really know what's being asked. Thank you.
Thank you. Who's next? It's what? Hold it. Stop. She got up first, but I understand the lawyer wanted to talk. So I let her speak. Now she's going to get up to speak. Oh, I have no idea. Excuse me. Ma'am, could you just sit down and you'll be called next? No, you have to be on the record. Please. All right. If we're going to conduct ourselves like this, I'm going to ask certain people to leave. All right? We're going to do it one at a time. They come up, introduce themselves, state their name and address for the record. When she's done, someone else will get up. And everybody gets one opportunity and only one opportunity. So collect your thoughts before you come up. All right?
Thank you.
I'm sorry. Go right ahead.
Okay, thank you. My name's Gretchen Muller, M-U-L-L-E-R, daughter of Charles Muller, who resides at 7 Seashell Lane. The address of my primary residence is 155 Greenpoint Avenue in Brooklyn. My dad has focused his comments on making sure the board and the public understand the truth about us and our property. So he has chosen not to say anything about the character of the neighbors who defamed him.
No. We're here for the variances. We're not going to start a bickering back and forth about character. We're concerned about the variance. If information concerning your property, so we can make a decision, that would be wonderful.
I agree, and I was thinking the same thing the first time we were here 5 months ago, but I'll sit down if I'm not able to speak about this.
It's not, the reality is that all of that just clutters the record. We need information that has to do with the property, that has to do with the history because of what we're being asked. So when you put those things on the record, it makes it very difficult for us to sort through all that information.
Okay.
On both sides. So.
Okay. Thanks anyway.
I think your father stated it very well.
I had so many good things to say, but.
Let me get, no. Good evening.
Good evening. My name is Eva Stark, S-T-A-R-K, and I live at 1 Seashell. Before I start, I want to apologize. I just assumed that the one side was finished and then the other side started. I just assumed that you didn't, it wasn't anybody who wanted to speak. So I apologize for being a little aggressive. Thank you for understanding. I'm going to try to make it short because I was here a couple of months ago and presented our case. I was asked to try to make it short, and I will. You know, we came here, and I've been here for 30-some-odd years at 1 Seashell, and we have proof of photographs. We have my word, a lot of other residents' word, that those buildings that they say existed as a home, as a dwelling, did not. They were shells without any additional things. So I'd like to take that into consideration. Nothing happened until 2001 when Lauren Longbotham came to live there, and he changed the house, the brick house. He added stuff, he added a balcony, he did a lot of things. He did that without a C of O. And then Mr. Mueller came along and added to all of the improvements without a C of O. And I want to say that the Airbnb was rented, the cottage was rented without C of Os. So I will say something that Mr. Mueller, I'm not going to try to defend myself or anybody else here. I'm not out to defend or besmirch anyone. But Mr. Mueller sent out a letter to the residents and his friends and family saying that a couple of the neighbors brought a lawyer to the hearing last time and made 40 false statements. I'm accused of bringing a lawyer to the hearing when he brought a lawyer. So if this is going to the character of who we're dealing with.
No,
Stop.
we don't want
I know, I didn't say that. So anyways,
And
my
no shouting
here is this here. This is not a referendum on Mr. Mueller, his character. It's a legal proceeding. I agree. And the only thing that we need to deal with is solely on the law. The environment is not in danger, nor is it a referendum on the environment. Rather, it's about the law governing the environment. So, Mr. Mueller has decided not to continue with Swan Park. And I have to tell you that my feeling, I have papers that talk about Swan Park. And he says it was created to encourage a community. They are park benches. It's a park on Seashell Lane. And it's as well as a barn with space inside for projects, meetings, presentations, and other events. This was his intention, to make this into a park. Then he sends out a letter to everybody in 2019 that says, "Thank you to all the people for attending the opening of Swan Park this past summer." Now, I didn't know that you could open a private park on private residence areas. This is new to me. 50 people representing 18 Salonga Seas families came together to celebrate nature and show community spirit. Clearly, Fresh Pond is valued in our community. With your ongoing participation, we can improve the health of this wetland habitat, enhance its scenic beauty, and provide new opportunities for outdoor recreation in our community. I don't need outdoor recreations on my private land. If you want to be involved in environment, great. If you're a nice person and plant, great. I have no issue with that. We have no issue with any of it. So here he is planning a park and planning things and inviting people and having 50 people over on Seashell that's about a road but so wide that you can't afford to have too many cars on it. And now that it doesn't suit him well, he's decided to close it up. But his initial intention was very, very different. And that, I think, speaks to whether or not there's honesty or anything else. I'm cutting it short, so I'm going after. If we do not, and the law, he wants to change the law of the 100 feet from wetlands. Now, what is the purpose of that? What is he planning to do with the property? Why does he need to change that? Why does he need a variance? They're very happy where they are. They love their house. They're happy with the community. What are they asking for? What is their intention? Why do we have to change all these things in order to gratify them? I don't understand that. It's not been made clear. So, of course, you're left questioning, why do we have to change a law that is in the books that says you can't build anything? And if he's not going to build anything, what are we doing here?
Can I just maybe clarify something for you? It might make it a little more clear.
I'd appreciate it.
When somebody presents something to this board, it's for the either existing structures that are there that they're trying to legalize, or for something that they proposed. So what's in front of us right now is only the existing structures. So this board can't change the law. We can grant a variance that gives relief from the law for either an existing structure or for one that may be proposed. But since none are proposed right now, it is only for what's existing.
Okay, so and let me ask you a question to make me better understand. What do we need to, why does he need to ask you to change the 100-foot ordinance?
Because by law, in the town of Smithtown, you're not allowed to have any structures within 100 feet of wetlands.
And the pond house, and the brick house is?
I don't believe it's the brick.
What
Maybe-
house are we
I believe the
talking
beach
about?
house is slightly encroaching. And the one, yeah.
I
I
don't
believe
think any
it's, I'm not
houses-
100% sure. I think it's the one that's on the beach front. I see that it's slightly encroaching.
On the
But-
beach?
Correct.
That's not where near the pond.
We can bring back the applicant
Okay.
and they can clarify that.
Okay.
But I just wanted to make sure that you knew that we do not have the ability to grant anything that's not before us. All we're doing is
Right.
looking at what's there and trying to decide what we can and can't approve and give relief from the town code for just that.
So meanwhile, all the laws have been broken. No C of Os. People living in houses without C of Os, all of them. There was a stop order on what he calls the barn, which was a little shed about yay high. It was never a barn. The structure that exists now is one of his making. And I will testify to that. We have pictures showing that structure. So, excuse me, I did not interrupt you when you were talking.
Look, we like to get through this tonight, and I'm sure you'd like to do the same. All right, so let's give everybody a little respect. And it's also difficult for the court reporter to take everything down if people are clapping or calling out. So please. Thank you.
Okay, I will try to finish up. So now he's looking for relief. He built all these things. The stop order didn't stop him. He continued. He thumbed his nose at the laws. He made a mockery of town of Smithtown laws. I've read them. They are very clear and concise. And he felt that it wasn't, he didn't need to follow those laws, but he wants now to change laws and rules that are going to benefit him. There are people who are building houses who require all kinds of permission, all kinds of laws that they have to follow, and yet nobody stopped him from doing any of it, and it was called to everyone's attention. What is he doing? Why are we allowing a person living in a place with no C of O? That's the law of New York State. What's going on here? If we can't follow the law and put the rules in, what are we doing? This is not, I don't dislike Charlie or his family. I have nothing against them. What I have against is what he's doing, which is illegal. And that sends a message to me that it's not right and his intentions aren't genuine. And meanwhile, I have to tell you, we live on this road. There are potholes from here to Kingdom Come. Mr. Mueller has the right-of-way in one section. We all have right-of-ways. A couple of years ago, we asked Mr. Mueller to join with us and the residents of Sechelle to donate money to pave the road because it was impossible to pass. He chose not to contribute to our community, to that road. So when he says he cares about the community, I don't know that I can believe him based on his actions, not based on his character. I can tell you, I don't lie. I'm not a bad person and I don't really care, but they besmirched me and the community. We are not here to judge character. We're here on the law. And I think if you know the law, you can vote on what is right and what is legal and why nothing has been done to change what's going on there. Thank you.
Thank you. Who would like to speak next? Good evening.
Good evening. My name is Paul Seglia, C-E-G-L-I-A. I live at 43 Senne Road, stone's throw from Charlie's house. Senne Road, S-E-N-N-E Road. I moved in 2019, so I'm kind of far removed from this, but from what I can tell you, Charlie's character, he's a stand-up gentleman. And the character of the neighborhood, people tell that, they would talk a lot about the character of the neighborhood. To me, Charlie's house is the character of the neighborhood. So I think if you grant the variance, he's gonna leave it the same, and we can go on about our lives. So, thank you.
Great. Thank you. Who's next? Good evening.
Good evening. My name is Dina Atlas. It's spelled A-T-L-A-S. I live at 11 Timberbrook Road in Fort Salonga, which is at the other end of the pond. I've lived there, I can't believe I'm saying this, almost 30 years. And when we first moved there, our road also was a gravel road, which is a lot like Sechelle Lane, which flooded all the time because we're on the water as well. So we have a similar situation going on over by us, but it is town regulated, so it did get paved about 12 years ago. We have had that done. So now we don't have as much water problems, but we still have the water problem. So I'm addressing the water issues that they also have at Sechelle Lane, which is on the other end of the pond. So in reference to water issues, like one of the people just had mentioned, the runoff and all that, it is something that we do have a problem with on all ends. If you go onto Fresh Pond Road, you have that same situation. I'm a walker, so I will walk, and I have walked my 3 boys through the neighborhood constantly. That's how I got to know Tia. But many years ago, when I first had my boys, I was walking with my children, and I met the Lothenbaum family. And I met them and the girls that were there. They were young girls, and I asked them if they would be a mother's helper. So I know this house for many years. So it was inhabited. It was a happy house, I would say, because there was 2 young girls who I would go and pick up, drive into the driveway, pick them up, and take them back to my house, which is a little 5-minute drive, but I wanted to make sure that they would come back and forth from the property to my property. So I came back and forth seeing this home. So the home was maintained. The home was, it was beautiful. It's more rustic. It's a farm-like area, and I still remember it as being like that, and it's still keeping that character right now when I go over to the house to see it, because I still do walk with my dog. So I see this, and Tia and Charlie have done a beautiful job, I think, maintaining the farm-like look of the house and keeping the character of the neighborhood, not overdoing the house, making it look appropriate to what you want to see on a nature preserve. You don't want to see a McMansion going, like you're looking out into the distance. You want to see the nature preserve. You want to see the wetlands. You want to see the geese. You want to see all the birds and whatever is on the area, in the area at the time, because we do have quite a bit of wildlife over here, and it's also in my backyard. And when I redid my house, I also kept my structure very simple. I didn't want to make a McMansion. I didn't want to go up high like many of the other houses in the neighborhood have done and put unusual things in their yards and such. This house has kept the quality of a farm-like look. And that is what I like about this home, because the home is an old home. Why not keep the character of an old home? Now, the barn that they're calling the barn, I used to see that barn. It was a little different. I will say that. It was a little different. I can't say it was small. It was not a small shed. I do remember the doors being a little bit different. And then one day I saw the doors just being a little bit more sturdy. They looked more sturdy. And in regards to like curtains and paint, they paint the walls, they maintain the place. That's what you do to an old home. You have to take care of it. Especially living on the water, you have a lot of, like you can put my house, when I first moved in, you can put your finger through the wood shingles. So you have to maintain and take care of everything. So that's what I assumed that was going on the barn. They have to maintain it, or the garage, whatever piece that's called that they're having an issue with. But otherwise, the house, yes, they came back and forth. They were not always there all the time, but I can tell you the girls were taking care of my kids, and my kids have a good memory of these little girls being mother's helpers for me. So I can say I've been there for a long time, and I know the house it was not ever abandoned. I did see a gentleman mow the lawn once in a while, and I think that was out of the goodness of his heart, because there was some hardships going on with the Lothenbaum family, which I can definitely say that they had an issue. So I know the gentleman is here, and I mean, that was probably out of the goodness of his heart to do that. But I think that's what a community does. And so right now, I think we're all standing here as a community trying to support a piece of property that really is historic in our neighborhood. And I love that house. When my sister came here to visit me a few months ago, we took a walk around, and she remembered it. And she says, I still remember this house because we used to walk around and see this property. So I see it as nothing more than a solid home, a home that's cared about, a home that's loved, and the other pieces that are there around it are as well. So I'm also very involved. I'm a beekeeper. I know that sounds weird, but I'm a beekeeper, and I do know Tia and Charlie are very involved with the nature preserve area of keeping the property in good shape. So that is something that I'm also appreciative of. I don't see any spraying. I don't see anything stupid being done in the nature preserve, so it will ruin the property of the pollinators and all that kind of thing. So I appreciate something like that as well. So thank you very much for letting me speak.
Thank you. Who's next? Good evening.
Good evening. Thank you very much. My name is Thomas Gallo. I'm residing at 28 Marion Lane, so I'm in the middle of this. And I wanted to tell you that I've lived in Long Island about 50-some odd years. I've lived in Fort Salonga for about 10 years, and I've moved around a lot. And this home that I'm in right now is everything that you could hope for. I'm retired and I'm slowing down, but I like to work outside, and I love the bucolic nature of this piece of property. And everyone that I have met so far have been wonderful. Charlie and Tia and her family, Tia's family, have been terrific stand-up people. And I know that they have everything in their hearts to make this environment even better. And I'm agog at the eloquence of some of the speakers tonight. But again, I couldn't wish for living anywhere else but in this property. Thank you.
Thank you. Who's next? Good evening.
Good evening. My name is Brian Sheed, S-H-E-I-D. I live at 1 Marion's Lane. I'm going to avoid any character references because you instructed not to. I'm just going to speak as a neighbor. From my understanding, they bought this property as is years ago. All the structures predate zoning laws. As a neighbor, I think every piece on that property completely fits our neighborhood. They're beautiful houses. Again, I've only lived there 5 years, so I can't speak to how they looked 30 years ago. But from my perspective, they are the most beautiful parts of our neighborhood. When we walk around, that farmhouse is iconic. It is unparalleled beauty that you can't find. And people come up here all the time and ask for variances for things to change, to modernize, and all these people are asking for is to keep something the same in the way that they bought it. And I feel like that would be extremely fair, and that's my perspective.
All right. Thank you. Good evening.
Good evening. My name is Howard Atlas. My wife just previously spoke. I live at 11 Timberbrook Road in Fort Salonga. As she stated, we've been living here for almost 30 years and love this area. Grew up on the South Shore, moved to the North Shore because we're just taken back by the beauty of Fresh Pond. And within the last year, I got to know Charlie and Tia. I didn't know them actually until the last year. And I was getting to know them and got the appreciation of the environment that they have, because we do. As my wife's a beekeeper, we have chickens. We really care about the environment, and we wanted to see what they were about. And that's all they spoke about was their true love for the area and the environment. And then when I heard that they were looking to get a certificate of existing use and it was being opposed, I was kind of, why would anybody oppose that? So I went back and looked at the hearing that was conducted in December, because I wanted to hear what the other side had to say. Why were they opposing this? And after I listened to it, I said to my wife, I said, wait a second, are we hearing all the right facts from Charlie and Tia? If you'd listen to that, you would think they were building the Taj Mahal, they're having a beach party house, and they were just looking to expand the property. So we talked to them about it, and we confronted them about all those issues, and they clearly made it clear to us that that was an issue, and it's clearly stated by Charlie eloquently and passionately, and refuted all those false allegations, which I was astonished to listen to, because they were truly false. If anybody knows this man and has gotten to know him, all he cares about is the environment, about his home, and he's maintained this property and maintained the integrity of this property in the area. He has done nothing to affect this area, and alternatively, has made it look nice. I'm just so grateful that they have bought this house and this property and have maintained it and are going to continue to maintain it so it doesn't lose its integrity and the beauty that surrounds this area. Thank you.
Thank you. Good evening.
Hello. My name's George Zaniel, 44 Brookfield Road. I've been a resident for 5 years, and to tell you, if everyone on this board had a neighbor like Charlie, not to go too much into the character, you'd be blessed. And if everybody on this board had, let's say, a piece of property to walk through, because the easement, basically, we can all walk through that property and enjoy it. It's beautiful, and it is a prize of Fort Salonga. And as neighbors with a concern for property values, our value is enhanced if you guys get this right. To get it right is to have this accepted, to have these properties with whatever it takes so that not only Charlie, but future generations, this community has this property, which is an asset to Fort Salonga, appropriately fixed by this board who can fix it. Thank you very much.
Thank you. Good evening.
Good evening. My name is Roy Griffin. I live at 38 Lister Circle in Fort Salonga. We've been there about since 2017. We know Charlie and Tia, and they do everything to maintain those properties. I walk the neighborhood all the time. Charlie's always out there cutting the grass, taking care of everything. Those homes look great. There's no problem with them. They do not affect anybody else's values. They're not dragging down the community. I wish everybody would keep those homes just as they are. As respect, someone said we were having some park benches. The park benches were maybe able to sit 1, 2 people. My 4-year-old grandson could probably sit on one, but not much else. So the idea that these are being used for park grounds is silly. And I really think that you guys should approve this. There should be no thought whatsoever. It does not affect any other neighbors. It does not affect anybody else's values. And it keeps the neighborhood looking beautiful. Thank you.
All right, thank you. Good evening.
Good evening. My name is Dr. Roman. I live in 39 Brookfield since about May 2019. Just the anniversary just passed. We love the neighborhood. We moved out from Queens, lucky enough before the pandemic. This was my dream home. I'm an immigrant. I came here when I was 10 years old with my family in 1995. And this neighborhood truly represents the American dream for me. And I have pictures actually with my children sitting on the bench on the, I guess, a seesaw right by the barn. And I just want to say it creates memories. And I will have those memories and cherish those memories for the rest of my life with my kids and show them the pictures. Actually, they invited me one time I'm an avid cook, so I cooked in their house outside where actually many neighbors came and enjoyed the food. And I'm very happy if you guys would make the right decision in their favor. Thank you.
Thank you. Anyone else?
Good evening. Jeff Cronin, 26 Fresh Pond Road in Fort Salonga. I've submitted a letter to the board, so I won't go through all of that. And I just wanted to say that a lot of the things that were said here tonight on these buildings and being built and created, none of it's true. 28 years I've been in the neighborhood, and all those buildings have existed. They've only been aesthetically improved. They're not, there's nothing that's been changed. So that's really all I wanted to say, and to submit the letter for the board's consideration. Thank you.
Thank you. Good evening.
Good evening. My name is Jason Reiser, R-E-I-S as in Sam, E-R. I live at 41 Brookfield Road, about 6 or 7 houses up from the property in question. My wife and I have lived here for about 12 years now. I had the opportunity just last night to reread the ZBA meeting minutes related to this property. The current board, being comprised of the same 5 members, I want to thank you for your diligent attention to the complex matters in this case. Your discussion and debate, which is included in the public record, clearly shows you're not lost in the weeds. You understand the issues at hand. I want to briefly touch on a few of those issues, if I may. Regarding the question of multiple houses without unique frontage, I think you previously correctly drilled down to the issue. that Seashell Lane is a private road. If that's not the case, you have 4 addresses on Seashell Lane beyond this property to the west that also appear to lack frontage. One of those, in fact, is currently tabled before you, case 18881. I can see an argument being made that those 4 properties have frontage across Fresh Pond in the town of Huntington, or is there frontage perhaps under water on the Smithtown-Huntington border? If this isn't an issue for the other applicants on Seashell Lane, why is frontage an issue for this applicant? I was intrigued by the arguments presented here previously about lack of continuous occupancy of these homes, and I think that some neighbors have shown that there's been concern in the past about the state of the structures. But this obfuscates the difference between an abandoned property and an abandonment of use. Again, I think you got this right previously. Neither the Mullers nor the Longbothams previously ever abandoned residential use of their property for some other use. They never sought approvals for some non-residential use, nor altered the property to be used for something other than residential. In fact, I would argue that photographic evidence of these residences, even in squalor, supports the argument that residential use was not abandoned. Abandonment of use involves intent. The question of size and nature of the house on the bluff came up, and I think you also previously compared the situations to homes in the San Remo neighborhood, smaller summer homes that have been improved for 4-season use. This is not unusual within the town of Smithtown. To treat this house uniquely would be unusual. In fact, this is an original Montgomery Ward house. I can't be sure of the model, but the smallest Montgomery Ward home I could find is called the Lawndale. It's a 30 by 20 home featuring 2 bedrooms, a living room, dining room, kitchen, and a bathroom. The literature consistently describes the structure using the word home and house, and that's what it is. It's a house with all the rights to use the house that pre-exist the zoning laws. On the subject of the barn being used as a business, I think this is a distraction. I'm certain that Charlie and his family have no more used this property as a commercial venture than I am that the Starks next door never operated a welding operation out of their home. But if you look at Google Maps, it shows Weld Art Studio, temporarily closed at 1 Seashell Lane. Clearly, these are not commercial uses. Neither of these is a commercial use. The Mullers' homes are residences, just as the Starks, just as the rest of us. I do think it's critical that the board examines the Article 78 findings and avoid the pitfalls it appears to point out. Some of these may be as simple as stating your findings, that there's no period of more than 12 consecutive months of use other than residential, something to that effect. The use versus area variances, I leave that to you. I have not done the required reading to dive into that. I'm confident you will take the time to ensure that your decision dots all the I's and crosses all the T's. I've previously called this property the very genesis of our community. It's exactly that. Longbotham created the subdivision from his farmland, and he retained 6.3 acres for himself while creating our 1 to 1.5 acre parcels. Whatever rights he retained over that property continue with the Mullers today. The fact that he may not be entitled to such relief cannot be possible if any of us is entitled to relief. That a lack of COs can make it uninhabitable due to lack of compliance with new laws doesn't pass the smell test. Thank you for your time and for making the effort to get this right. I appreciate it.
Thank you. Who's next? Good evening.
Good evening. My name is Lenny Piscores, and I reside at 22 Marions Lane. To answer your question, Mr. Tanzi, the garage was built in 2001, and you have pictures in the previous applications of what was there. It was a 6x6 shed that was knocked down, and the garage was built there in its place. I just have a comment from one of my neighbors, asked me if I would read it to you. He couldn't be here today, 20 Marions Lane. His name is Bob Schifoletti. I built my house over a 2-year period and moved in February 2021. My contractor and I looked to and did comply with rules and regulations as established or reinforced by this board. It was at times challenging, however, we did comply. There are reasons for rules, and we respect them. Since we've moved in, my neighbor has used one of his houses as an Airbnb. It is directly adjacent to my property. Renting only appears to have recently ceased after a decision by the board was deferred in response to the applicant's request. I share with this board at the last hearing problems with renters having used binoculars to look into my home and illegal beach fireworks and fires throughout the summer. Having a 17-year-old daughter in my house has caused her and me great concern. My neighbor also believes it is his right to come onto my property at will. Just the other day, he was on my property talking to some workers. Previously, I had seen him on my property measuring my patio. When I asked him what he was doing, after 3 responses of just admiring the house, he finally admitted he was embarrassed and was going to leave. I guess he's a person that wants to make sure others comply with the rules. However, he believes he is special and deserves special rights and needs not comply. What he is asking for violates many rules. I appreciate the board considering my comments. I unfortunately couldn't make tonight's meeting. Very little warning was provided to us about the meeting. I will make sure I am available to you on the future to answer any further questions. Thank you. First, I would like a request that the files from the previous applications on this matter become a record in this variance hearing. Files number 15558, 15559, and 17178. I would like to respond to the 5 questions. Whether an undesirable change will be produced or a detriment to nearby properties will be created by the granting of the area variance. The current structures have not all been in existence for the last 45 years. I moved into 22 Marion's Lane in 1998. At that time, no one lived in any of the structures. The property was abandoned and overgrown and hadn't been lived in over 10 years. When the Longbottoms came to again occupy the structures in 2000, they made additions to them. The additions are shown on the map with each letter from the building department depicting what was the original and what was added. The pond house was made larger and additions were made onto the brick house. The shed near the brick house was removed and replaced with a 6-car garage in a hazardous flood zone. Clearly, the applicant cannot establish the requirements for a certificate of existing use. The board should deny that request. Whether the requested area variance is substantial. Yes, the variance is substantial. According to Chapter 322, Zoning Article 12, Board of Appeals, in cases where a lot does not meet the area and/or frontage requirement, the board shall not grant more than 3 variances. The applicant is requesting many variances. The board should consider this request substantial. Each of the non-compliances in and of themselves are substantial. For example, the town has already determined that the buildable area is 1.7 acres. The applicant should not be permitted to have the increase by allowing environmentally sensitive land to be used for this calculation. Number 3, whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. The applicant stated that the removal of the improvements would have no benefit to the community. Yes, the applicant could be asked to remove auxiliary structures. Some are in the flood zone, some illegally built, not all up to code and dangerous, most without CEOs. The applicant could adhere to the LWRP to rectify this situation. As it was determined at the last variance hearing, the property is overdeveloped as it stands today. Now, as part of this variance application, there are plans submitted to renovate the garage into a recreational space, which includes removal of the garage doors and replacing with French doors, adding air conditioning, heating, and a bathroom. Actually, a waste line was trenched from the garage to the brick house cesspool. As far as I have seen from development in my community, anybody that's been building anything new has had to put in new style septic systems. There are no new style septic systems on this property. In my opinion, that is no longer a garage. Not really sure what the intentions are. This garage is in the hazardous flood zone, and the line delineating that goes through the garage now. whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood district. The environmental impact is as stated in the 2008 LWRP. The addition to dwelling 1, the original dwelling, which had a footprint of 950 square feet, was approximately 65 feet from Fresh Pond. The existing additions increased the footprint of the dwelling to 2,087 square feet, a 220% increase of its original size, and brought the building about 8 feet closer to Fresh Pond. There's no drainage structures on the site to intercept the increased stormwater runoff from these additions, meaning no dry wells, no nothing. All the leaders are just running out into the pond. Addition to dwelling number 2, the original dwelling had a footprint of 1,055 square feet and was approximately 68 feet from Fresh Pond. The existing additions increased the footprint of the dwelling 2,448 square feet, an increase of 232% of its original structure. There's no drainage structures on that either, and increased water runoff from these additions. The detached garage adjacent to dwelling 2 is approximately 91 feet from Fresh Pond. Again, there are no drainage structures to intercept the storm water generated from the detached garage and constantly floods out Seashell Lane. The detached garage does not comply with the flood policies of the LWRP. The western half of the garage is in a flood hazard zone. I'm not claiming to be qualified to make these points, but only to read the points made by the LWRP. Since the last hearing, 8 years ago, Mr. Muller has completely renovated without permits the beach cottage, adding plumbing, heating, air conditioning, kitchen, bathroom, and a washer and dryer. Also added a 250-foot paved driveway, which is not pitched into anything but the road. It goes directly down to the road, and I have video footage of it if anybody would like to see it on my phone. These things were done with no regard to proper drainage. Water runs down the driveway and completely floods Seashell Lane and drains into the pond. All of these things create environmental issues. Now, this cottage has been used as an Airbnb for the last 3 years. This is not the aesthetics of our community, nor is it a property recognized by the town to have 3 dwellings. I've actually pulled the tax records for the last 15 years of this piece of property. And the property has been taxed as 2-family lot. Clearly, this structure on the Sound was never a finished, viable house until the applicant did the renovations. And I have 15 years of property taxes. Whether the alleged difficulty was self-created. All the additions were made in the time when zoning requirements and building codes were very structured, which was 2000 and after. The applicant is not a stranger to this property or neighborhood. He was very aware of these issues with this property when he made his purchase. I even had a conversation with him prior to his purchase about such issues. I recommended to him at the time that he should investigate the property before purchase because many additions were made without permits and a large portion of the acreage is underwater or in a flood zone. He bought the property without doing that, and therefore he has created any difficulty or financial impact upon himself and by himself. In closing, I am asking the board to take a serious look at these variance requests. If a new applicant came to you today, applying to build and extend these structures now, would you give approval? I suspect that would not be approved. The board must only grant the minimum variance that it deems necessary and adequate, while at the same time preserving and protecting the character of the neighborhood and the health, safety, and welfare of the community. Mr. Muller got approvals for all his variants at the previous hearings. All the approvals were done with conditions that you put in. These conditions were all environmental conditions. Dry wells on every structure, rain gardens, all these things that were supposed to come to the board and get approved and be installed. Today, he has not implemented any one of those. Quite to the contrary, he continues to build on the property and create more environmental issues.
I'll put that in the record. Okay.
Any questions? Thank you.
All right, thank you. Anyone else? Anyone else? Come on up, sir.
Hi, Doug Wohl, W-O-H-L, 10 Marion's Lane, Fort Salonga. Just one or two quick little points. I built a house on the property that I bought there, and I had to follow all of Smithtown's rules and regulations. As a matter of fact, it was determined that my patio encroached 10 square feet into the LWRP. You might think 10 square feet is 3 by 3, a big thing in the LWRP. No, it was 6 inches into it, 20 feet long. So I had to fix that. We're talking about 6-inch encroachment. We're not talking about hundreds and hundreds of feet. There's rules for a reason. I have easement going through my property. Matter of fact, neighbors here who uses that easement, I had to make sure that that followed all the rules in the deeded easement. The rules are for everybody. Nobody's a mean person in the neighborhood. It's a beautiful neighborhood, just like everybody's been saying. But kind of rules are rules, and they're there for a reason. As a matter of fact, Matt knows me, because I'm building some houses in town of Huntington, and we're following all the rules there. So I'd just like to make sure that everything's equal for everybody.
All right.
Thank you. Have a good night.
Thank you. Good evening.
Good evening. My name is Charlotte Muller, M-U-L-L-E-R. I live at 55 Normandy Drive in Northport. So I just wanted to say that we've heard a lot of rules are rules, and I agree with that. And I also am we're here, it's a variance hearing, right? So rules can be amended and can be changed. So I just want to stand up here and say that my family is an asset to Fort Salonga. Tia and my dad are incredible to the community and to the property, and I look forward to raising my children on that property, hopefully one time soon. So I really hope that you'll consider. Thank you so much for your time.
Thank you. Anyone else? Anyone else? No one else? All right, I'm going to bring them back to answer some of your concerns, and that's it.
Okay. First and foremost, I just want to address the request to keep this hearing open. I think the issues have been amply vetted. I think both sides have been amply heard. I'd request that the hearing be closed today. I don't see what would benefit this board by holding it open, but of course that is the board's discretion. I'm just voicing my opinion. To start, I take some major issues with Ms. Perillo's statements. Perhaps she's unaware of the actions of her own law firm, having not previously been at the hearings. You know, I appreciate her fervor. However, quite frankly, I don't think anything that she stated is actually correct. So the notice that was sent out meets the town's template. We've used it many times in other applications for this board. The town's requirement actually is not specific for the mailing notice as to what it's supposed to contain. The only provision that states exactly what needs to be in the notice is the published notice in the newspaper. That contains a pretty lengthy summary, which Mr. Donadio read, of the relief that's being sought. That being said, the notice that was mailed out by my office, which was timely and was not short, contained all of the required information per the town's template. So these repeated assertions that things were made unclear or were kind of hidden behind the 8-ball, I take particular umbrage to, because I feel like it's part of a smear campaign, which is unjustified, because we've complied with the notice requirements. And to the extent that Ms. Perillo is somehow accusing us of seeking improper relief in seeking an interpretation from this board, first and foremost, as this board will probably recall, it was her colleague who got in front of this board at the last hearing and said this application is not properly noticed because they did not say in the application, and they did not check the right box to request an interpretation from the code. And so in the break of proceedings, that is exactly what we did. So to now attack us for having done that, I feel like is incredibly duplicitous. Any reference that was made about having to provide town-wide notice of a request for interpretation, I'm not sure exactly where that comes from. As I'm sure this board knows, it is strictly within your purview to provide interpretations of the zoning code when there is an interpretation first by your building director. It is not an advisory opinion. It is a form of appeal. This is an appellate board. It is quasi-judicial. So you can either hear variances, you can hear interpretations, you can hear both. In this case, we are seeking an interpretation from the building director's interpretation as set forth in his notice of denial. Alternatively, we are seeking the appropriate area variances. So again, I take particular issue with the comments that we've somehow done something incorrect here. I'm not sure why we are talking about the LWRP at this current juncture. An application has been made to that separate agency. There is overlapping jurisdiction here. Obviously, we're not done with anything until we get the approval from all the necessary boards. The town board action, if that is in fact something we need to pursue, will be pursued at the appropriate time. We're here before this board now because we were directed to make the application by your planning department. We're not seeking a use variance. The code requires us to meet the use variance standard for the expansion of a, quote, non-conforming use. First and foremost, we disagree with the interpretation that any one of the residences for which we are seeking the certificates is a non-conforming use. We disagree with that. That is part of the interpretations we are seeking. To the extent this board disagrees with our position, we then have to argue for the use variance standard. We do not agree, nor do we concede, that any one of the residences is a non-conforming use. So let me make that clear. I find it interesting that Ms. Perillo stated that the residential uses are inconsistent with environmentally sensitive land. Around this pond alone, you have 20 properties. All but one of those properties has a single-family residence sitting on it. So if these 3 residences, which are on environmentally sensitive land, are somehow intrusive, imagine what the impact from the other 20 existing residences is. I think on its face, that argument does not pass the smell test. The area variances were discussed at length during the last hearing. Ms. Perillo was not here, so perhaps she did not review the record and was not aware. Moving on to Ms. Stark. We've heard a lot about photographs of what the condition of the property was previously. They haven't been produced to this board in this hearing or the prior one. I'm wondering where they are. To the extent that she says they depict conditions of either one of the residences, boarding up, shacks, whatever she wants to describe them as, we do have now the email, which I've provided to the board from Mr. Longbotham, that explains that prior to 2001, those residences were seasonal. Therefore, they were not lived in year-round. So they were boarded up and, by all appearances, may have looked uninhabited. I take particular issue with the fact that Ms. Stark describes this purely as a legal proceeding. If we are just talking about legal process, I don't understand the objection that's continually made to approval of this application. It begs the question what Ms. Stark, Ms. Pizkors, and the other residents in opposition want from this. I'll say again, I made every attempt to reach out to them to find out what they want as the ultimate relief in this situation, and I've had no cooperation. The notice Ms. Stark presented to the board is from 2009. As I think I made clear earlier, Mr. Mueller and his family are not currently attempting to hold meetings of SWAN at their property, so I'm not sure what the relevance of a 2009 notice is at this point. A lot has been talked about changes in conditions and changes in the environment. As has been made clear, the issues that we're talking about all exist, with the exception of the reconstructed garage. All of the residences, the garage next to the beach house, the pump house, any structure of any import here has existed on this property prior to the town zoning. So the fact that everything's there, I'm not sure why we're still talking about what was done or what needs a CO. The reason we are here is to get the COs, in this case CEUs, so that the property can be used for legal residences. The fact that Mr. Mueller came to the property and those things were not in place, again, is not his fault, but that is why we are here. He is the one trying to clean this up. So these allegations that property has been used for residential purposes without COs, yeah, but that's the purpose of the application. So I don't understand what the point of bringing that up is now when we're here to fix that problem. I know Ms. Stark made mention of people proposing things on her property. No one obviously is proposing anything on her property. Any gatherings of any sort would be strictly on Mr. Mueller's property, but again, he's no longer having gatherings on his property apart from social gatherings at his family. To clarify the earlier question about the 100-foot setback, all three of the existing residences are partially within that 100-foot setback, which is why we need the relief that we're seeking. We're not seeking to change the rules with respect to the setback, as I think was already made clear. We are seeking a variance from that standard, as I think this board appreciates. I think it's ironic that there's complaints about park benches when Mr. Mueller has a private road that runs directly through his property and has other people driving on it every single day to reach no fewer than 4 houses at the far end of Seashell Lane. So the idea that these benches are somehow indicative of public use when he has practically a public road running through his property, I think is just a little comical. On to Mr. Piskor's comments. Again, I'm not sure why we're talking so much about the garage. The garage is permitted. It's not one of the structures for which we're seeking the CEUs. So the fact that it was demolished and reconstructed, the conversation about whether or not it's a continuing non-existing, non-conforming use is irrelevant. Again, there was a lot of mention of the Airbnb. That is no longer being conducted on the property. Mr. Piskor has also attacked our notice. As I think I made clear, the notice was compliant. He asked for the prior files of the prior proceedings to be part of this record, which is fine by the applicant. I think all of the information is relevant. However, it's ironic that his attorney got up here not too long ago and said that this is somehow a new, revised, amended application. The statement is also duplicitous in the fact that, again, we amended the application at their suggestion. Mr. Piskor stated that he moved to the property in 1998 and that the two residences, the brick house and the cottage, had not been lived in for 10 years. I'm not sure because he didn't state how he knows that to be the case when he moved to the property in 1998. Again, Mr. Longbotham said that the properties were seasonal until 2001, so to the extent that there are photographs showing the property boarded up, that would be consistent, not inconsistent with Mr. Longbotham's statement that the residences were previously seasonal. Again, the statement was made that the property is overdeveloped. I think Mr. Morris made the point that in relation to other properties in the area, considering the scale of this property and the nature of the modest-sized homes, this property is nowhere near overdeveloped. For any of the board members who have not gone to the property and see it, I think it would be very beneficial to go and see it. Mr. Piskor has also stated that the lack of adequate drainage on the existing residences is the cause of flooding on Seashell Lane. First of all, that is very clearly his opinion. I don't think he's produced anything that shows that these residences are the genesis of flooding on Seashell Lane. We just heard from another resident who said that she lives in the area and that flooding of the private roads is a common problem. That is not surprising when you have a residential community situated around a freshwater pond, as you do here. The tax records that Mr. Piskor provided for the, the tax bills that he provided for the record, again, this is his speculation as to what those records show. The fact that the cottage was somehow not reflected in the tax records as a livable residence is not proof that it was not habitable. This is just his interpretation. To the extent that there were conditions imposed on the last approval that was overturned, I think Mr. Mueller made a good point of stating earlier that, this night that he attempted to comply with the conditions that were imposed with the prior approval, but once it was overturned, he was no longer able to do so because he no longer had the necessary variances to undertake the work. It is something that we can certainly discuss as to whether or not he is able to move forward with those same conditions if this board is willing to approve the application a second time. And I believe that is all that I had. So again, I would like to reiterate my request that the hearing be closed, the record be closed, and that this board issue a decision on this application.
All right.
Thank you very much.
All right, can I have a motion to close the application, please?
So moved.
Motion has been made to close the application. It's been seconded. All in favor?
Aye.
Motion carried. Thank you all, and good night. And that concludes our meeting for tonight.